Hello, how are we? Hi, Judy Pip. How are you, my darling? Good to see you. Badaza. Now you're in the bad books, Badaza. Mighty Meat was yesterday. I was telling him everything about you. He's like, the motherfucker. No, I'm joking. How are you? Hope you're well, Badaza. The court is there, the judge is there, but they haven't started yet. So just a reminder, we got closings today. They shouldn't be that long, to be fair. I can hear the court now. They shouldn't be that long. So we'll see.
Morning.
Morning, Katie. How are you, my darling? Right, let's see what the judge has to say.
And everything else is either the trial here, the trial in front of Adams, or a case that's already played. All right, so we're done with the docket for the morning.
Hang on. The jury are not there, I don't believe, so they're just discussing other stuff. But yeah, a murder trial. The defendant's not there either. Defendant's not there yet. So a murder trial that lasts one day, and that includes the defendant taking the stand. Wow. Wow. I wonder how long it's going to be to get a verdict on this one. Is that, yeah, that's the lawyer. I think that's his mother. That's him. Ask Mighty what he did when my laptop crashed. He was here yesterday. He's giving you the big one yesterday. I love Mighty. Hey, Sue, how are you, my darling? Nice to see you. Yes, I know.
I'm pretty good. Thanks.
That's good, Siri, but I didn't ask you anything. So I think like an hour for a one-day trial. Probably, yeah. I think, depends what they think. But yeah, it's going to be short. Hello, Terry. How are you, my darling? Nice to see you. It's going to be short, I think. Not a long one today. During the verdict watch, I've got the episodes I was going to show yesterday to play when they're on verdict watch. And if there's no new trial tomorrow, what I'm going to do is do another trial that is actually going into closing arguments today. And it's probably a full day, a 12-hour day. But I'll say that more later on if there's nothing. Hey, Bud. Hey, Dana. Tracy was amazing last night. If you didn't see her, resisted the silence. Tracy, as always, was awesome. Dana was, I think I did a better job behind him. No, I'm joking. It's a good show. Brandy being Brandy. I'm glad Mighty Meat's not here because Mighty Meat will be watching. He loves Brandy.
Thompson on behalf of Mr. Dority.
Right on. Mr. Dority is also present. All of our jurors are back. I have handed out copies of the jury instructions to all parties. There's copies for the jurors, and I do have the verdict forms up here that we all discussed yesterday. Any other matters or issues that I need to discuss or take care of from the state?
No, Judge, just for as far as jury instructions, do you read the majority of the instructions before closing or after? I know judges split them differently.
I don't have a preference.
I typically prefer the majority of them to be read before, but again, that's obviously,
I don't have a typical practice. If you want me to do it, I'll do it. If you don't want me to do it, I won't do it. If you want me to do it, tell me where you want me to stop at.
I have no preference either way. I have no preference either way.
Morning, Mama Ames. Morning to you.
I would suggest potentially going up until rules for deliberation, stopping there, and then closing arguments, and then going to the rest of the way from rules for deliberation. It's on page 12 of your instructions. Or 13.
Okay, so you read up through the rules for deliberation, stop there, have you do your closing, and then read those remaining
Page
3 or
12.
4 instructions and send them out.
That would be the state's preference, if everybody else is in agreement.
Any objections?
No objection, Your Honor.
Okay. And I'll do that. Anything else from the state that I need to address?
Nothing further from the state.
Anything from the defense?
Nothing.
All right, we discussed yesterday, each side's agreed to do their closings in 45 minutes or less per side.
Yes, Your Honor.
Yes, Your Honor.
All right, we do have all the jurors back, so let's go ahead and bring them in.
So an hour and a half maximum for closings then. But the 12 pages, or how long is it going to take to read all the jury instructions? And there's more after that as well. Oh, stuff. Were there any witnesses? There were 6 witnesses and the defendant.
All right.
All right, have a seat. All right, ladies and gentlemen, welcome back. I trust that you all complied with the instructions. You didn't do any investigation or any research on your own or have anybody have any contact with you reference this case over the evening, correct? All right. When we spoke yesterday, both the state and the defense had rested their cases. The court released you all early so that we could finish the jury instructions and the verdict forms. We have completed that. You do have a copy of them. You're free to take those back into the jury room with you. What we're going to do is I'm going to split up the way that I read the jury instructions a little bit. I'm going to read the majority of the jury instructions through about the top of page 13 to you now. I am required to read the jury instructions to you. I give you a copy so that you can take them into the jury room with you, but I have to read them out loud to you. The reason I'm reading the first about 12 pages to you is so that you hear from me what the law is that applies to the case before our lawyers argue to you what the law is and what the facts are that may apply to that law. So you'll have heard it from me first, so you know what the law is as they make their arguments. Then they will do their closing arguments, and then I will pick up on page 13 with the last few instructions before I send you out and go over the verdict form with you to let you deliberate, okay? All right, so with that said, we'll go ahead and start with the reading a portion of the jury instructions before they do their closings. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Lawrence Alexander Dority, the defendant in this case, has been accused of the crime of second-degree murder with a firearm. In this case, Lawrence Alexander Dority is accused of second-degree murder with a firearm. Murder in the second degree includes the lesser crime of manslaughter, which is also unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Adreian Payne was killed by Lawrence Alexander Dority, you will then consider the circumstances surrounding the killing and deciding if the killing was second-degree murder, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and adequate provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Lawrence Alexander Dority may be found guilty of second-degree murder or any lesser included crime. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Adreian Payne is dead. 2, the death was caused by the criminal act of Lawrence Alexander Dority. 3, there was an unlawful killing of Adreian Payne by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another person and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and 3, is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. An issue in this case is whether Lawrence Alexander Dority did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because he acted in the heat of passion based upon adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Lawrence Alexander Dority was in fact so provoked and did not cool off before he committed the act that caused the death of Adreian Payne. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because he acted in the heat of passion based on adequate provocation, you should find him not guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime, he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of second-degree murder with a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed second-degree murder, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty of second-degree murder. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he actually possessed a firearm, you should find the defendant guilty of second-degree murder with actual possession of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm, you should find the defendant guilty of second-degree murder with discharge of a firearm. If you find that Lawrence Alexander Dority committed second-degree murder and you also find beyond a reasonable doubt that during the commission of the crime he discharged a firearm and in doing so caused the death of Adreian Payne, you should find the defendant guilty of second-degree murder with discharge of a firearm causing death. A firearm is legally defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. To actually possess a firearm means that the defendant A, carried a firearm on his person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, You will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of second-degree murder is manslaughter. To prove the crime of manslaughter, a lesser included offense of count 1, the state must prove the following 2 elements beyond a reasonable doubt. 1, Adreian D'Angelo Payne is dead. 2, Lawrence Alexander Dority intentionally committed an act or acts that caused the death of Adreian D'Angelo Payne. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that Lawrence Alexander Dority committed manslaughter, and you also find beyond a reasonable doubt during the commission of the crime he personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find him guilty of manslaughter with a firearm. A firearm, again, is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive. If you find that Lawrence Alexander Dority committed manslaughter, but you are not convinced beyond a reasonable doubt that he personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find him guilty only of manslaughter. It is a defense to the crimes of second-degree murder and manslaughter if the actions of Lawrence Alexander Dority constituted the justifiable use or threatened use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Lawrence Alexander Dority does not have the burden of proving that he was justified in using or threatening to use deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force is as follows. Lawrence Alexander Dority was justified in using or threatening to use deadly force if he reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to himself, or the imminent commission of a forcible felony, aggravated assault, against himself. The definition of aggravated assault is as follows. An aggravated assault is an assault with a deadly weapon without intent to kill. An assault is an intentional, unlawful threat by word or act to do violence to the person of another, coupled with an apparent ability to do so, and doing some act which creates a well-founded fear in such other person that such violence is imminent. Lawrence Alexander Dority had no duty to retreat before using or threatening to use deadly force. In deciding whether Lawrence Alexander Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. However, the use or threatened use of deadly force is not justified if you find that Lawrence Alexander Dority used force or threat of force to initially provoke the use or threat of use of force against himself, unless 1, the force or threat of force asserted towards the defendant was so great that he reasonably believed that he was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using or threatening to use deadly force on the victim. Or 2, in good faith, Lawrence Alexander Dority withdrew from physical contact with Adreian D'Angelo Payne and clearly indicated to Adreian D'Angelo Payne that he wanted to withdraw and stop the use or threatened use of deadly force, but Adreian D'Angelo Payne continued or resumed the use or threatened use of force. In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Lawrence Alexander Dority and Adreian Payne. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict of the evidence, or the lack of evidence. If you have a reasonable doubt, you must find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? And 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1, whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2, whether anyone had promised him anything in order to get him to make it. If you conclude that the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, I'm going to stop reading the jury instructions. At that point, I will pick up with the remainder of the jury instructions after the attorney's closings. As I indicated, both the state and the defense have now rested. The attorneys will now present their final arguments to you. Please remember that what the attorneys say is not evidence, nor your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendant has spoken. Does the state wish to give their closing at this time?
Yes, Your Honor.
You may.
Thank you, Your Honor. May I please report? Carol Walker pled with the defendant not to take his gun out. She pled with him, don't take your gun out. Over again, don't take your gun out, Lawrence. We were asked to come here. She pleaded with him not to shoot Adreian Payne that night. But he didn't listen. Instead, he proceeded to take his gun out, take deadly aim, and shoot and kill Adreian Payne. It wasn't justified. It wasn't in response to a reasonable threat. It was just because he was intoxicated and he was mad. Not in the heat of passion that would be justified by law, but just because that's how he felt like, what he felt like doing that night. Not justified. Now, this was a relatively short trial. You heard from 6 state witnesses, as well as the defendant, including Tara Walker. And obviously you heard from the witnesses yesterday, so you probably have fresh memories of what was said, but I want to go through and touch on what I think are important points for you to remember when you go back for your deliberations. First, you heard from Corporal Garrett Morris. He was one of the first responding officers on scene. Now he came to the scene and he found the victim suffering from a gunshot, and he was still in his vehicle. Now you heard from the testimony, he was a large individual. He was 6'8", and they had difficulty getting him out of the vehicle. They were able to ultimately get him out. He tried to render aid on the ground at CPR with another officer. Unfortunately, he was unsuccessful. Now you heard as part of protocol for when responding to a scene like this, a shooting, that he checked for weapons on the victim's person. And you can actually see on his body camera video that you saw that he did check both a pouch that the victim had on and as well as his pockets. No weapons. You also heard from CSI Hannah Miner, who testified yesterday morning as well. She was the lead CSI in the case, and she was in charge of documenting the entire scene, including the inside of the victim's vehicle. And you saw her documentation of that scene produced no firearm. There was no firearm in the vehicle. There was a kitchen knife in the passenger floorboard that you heard from Tara Walker was put there by her after a dinner that they had picked up. You also got to see from CSI Miner's photographs sort of a layout of the scene. You got to see that the victim's vehicle wasn't parked right in front of the defendant's house, but down the street a ways, at least a couple of residents down. You saw that the vehicle wasn't on his property. It wasn't on anything adjoining his property. You got to see the distances between the defendant's door and where the victim had parked. You got to see her photographs detailing her search of the defendant's residence where the firearm was found. And you saw the firearm itself, which is in evidence. You heard briefly from Marco Quintanar, who was a neighbor in this incident. He didn't see anything, but he heard gunshots, which caused him to look at his surveillance camera, and he was able to find video that captured audio of this shooting. And of course, you heard from Tara Walker, the victim in this case, his girlfriend, the mother of his child. She told you that she responded to the area of the defendant's house after receiving a call from her best friend, Tatiana Mesa, that she then spoke with her boyfriend, Adreian, who said he was also en route there as backup to her. Now you heard that she got there sort of just after Adreian had arrived and saw the defendant sort of walking away after apparently having words with Adreian going back into the house. You heard she had a brief conversation with him. He was going to move his car so she could fit to park on the street there. And then you heard that's when things took a turn. The defendant came back outside the house. He didn't stay in the house. He didn't lock the door. He didn't call 911. None of that. Instead, he arms himself with a firearm, taking the time to do that. He comes back out, and when Tara Walker sees him, she notices that he seems to have a gun. And she says, and you can hear on the audio, "Don't take your gun out. Lawrence, don't take your gun out. We were called here." But then she told you he didn't listen. He does take the gun. You can hear the escalation in her voice. While you can't see the incident, you can hear it play by play from her voice on the video and the shots themselves. And you hear just after that, after he's been warned, after he's been told why they're there, you hear the shot ring out. And then you hear screams. Because the defendant had killed Adreian Payne for no justifiable reason. And you hear that in that surveillance. You then saw on the video, and you heard from her, that she ran down to a neighbor's house. She tried to get help. And then she continued running, trying to get help from other neighbors. And then ultimately, when law enforcement came back, she was back to the car to try to render aid to her boyfriend, who unfortunately succumbed to the injuries. Now, you also heard from the medical examiner in this case, Dr. Marie Hansen. She told you about her extensive experience as a medical examiner since 1990. She told you about the autopsy she performed in this case. And she told you about the positioning of the victim's body when he was shot, that his arm would have had to have been up like this and to go through his torso for the shot. She said that was consistent with, and obviously she wasn't there, so she can't say specifically, but it was consistent with someone having their arm either perched on a door frame or on a steering wheel, just as Tara Walker said. She also said that based on the position, it's likely that the thumb was down. That's not a position that someone would be pointing a firearm, which we know that the victim in this case never had. But instead, a position of somebody that's by his car or in his car, nowhere near this defendant's residence, not on his property when he was shot. You heard from the medical examiner that the cause of death was that gunshot as it went through and pierced the aorta, and you heard that the manner of death was homicide. You also heard from firearms expert with FDLE, Kristen Killinger, just that confirmed that the gun that was found in this defendant's home was in fact the gun he used to kill the victim in this case. And that the bullet that was removed from the victim in his autopsy was in fact fired from that defendant's gun. Now, you also heard from the defendant in this case, and part of your job, as is your job with all the witnesses that testified, is to weigh their credibility. Now, the judge just instructed you with an instruction on weighing the evidence, and it goes through the factors that you look at when weighing the credibility of a witness that testifies. And that's your job as a juror, to go through that with each witness and determine what you find credible and what you find to be not credible. Now, I want to talk about some of those that are of particular importance, I believe, to this defendant's testimony. Did the witness seem to have an accurate memory? Well, you heard his testimony as he said certain things with his counsel, but then when I questioned him about it, I said, well, it had been a long day, I'm not sure, I might not have said it. Did you find that to be credible? Was the witness honest and straightforward in answering questions? Well, he was barely audible when answering questions from his attorney, but he was at least cooperative. But then when I asked him questions, you saw his response, talking around the question, not giving me direct answers, having to be impeached multiple times with his previous statements. Did the witness have some interest in how the case would be decided? Well, no one that you heard from yesterday has more of an interest in how this case is decided than the defendant, obviously. Did you find his demeanor on the stand to be credible? Or did you see the tears, if there were any, to be crocodile tears that he was trying to force to gain sympathy from you? What do you believe? Did his testimony agree with the other evidence in the case? Well, no, it was in conflict with the testimony of Tara Walker. And that testimony of Tara Walker is corroborated by the video and the audio from the surveillance video. And did the witness at some point make statements inconsistent? Well, several times. I mean, just out of the door, in his direct testimony, said he had never been Mirandized. But then obviously he was impeached on the transcript of him being read Miranda. He said that he, didn't initially, so they didn't try to talk to the victim when he came back out. He didn't communicate with him. He shot him. That's what he said just after this murder. But then after watching all the evidence, he gets on the stand and says he came out there and was trying to, talk, please leave, please leave. First of all, I question that is the demeanor that he came out and was asking Mr. Payne to leave. But also, Adreian Payne was not on his property. He was on a street that was not even touching his property, and he didn't have any less of a right to be there than the defendant. He also said definitively, as you heard in his direct testimony, he definitely saw a gun, but he never said that in his initial statement. What he said is he thought he saw the outline of a gun. He's not sure, to be honest, he's not sure. That's what he originally said. But after hearing the evidence and realizing what needs to be said in order to convince you that he was somehow justified in his actions, that's what he said on the stand. But it's not consistent with what he said before, and it's not consistent with the facts and evidence in this case. Now, from the evidence in this case, it is clear that this defendant is guilty of second-degree murder with a firearm. The judge just went over with you the elements of that offense as well as the lesser-included offense of manslaughter. But I want to take a minute and go through those with you as well and go through the facts as the state believes they apply. So the judge will instruct you and you have in your packet that you are to convict of the highest crime proven beyond a reasonable doubt. And that's second-degree murder. Now, here there's a lesser-included offense of manslaughter, but I want to be clear, and I'm going to talk about manslaughter, but I want to be clear. In jury selection and in these instructions, you're going to be told to not let sympathy or concerns about sentencing impact your deliberations in this case. So if you believe that we've proven this case beyond a reasonable doubt regarding second-degree murder, it is not appropriate to say, well, maybe he was scared even if it wasn't justified, or maybe whatever the situation is, he's, not that old. I don't want him to, go to prison for a long time, or whatever the case may be. That is not appropriate. That is not the consideration for the jury. You are to convict of the highest offense proven beyond a reasonable doubt, and that's second-degree murder. But I'm going to talk about manslaughter because we have proven the elements of manslaughter as well, as it is a lesser-included offense. So to prove the crime of manslaughter, the state must prove it's just two elements. And there's a couple of big differences between manslaughter and second-degree murder. First, there's just two elements. There's three elements to second-degree murder. Manslaughter does not require any type of mental state. So second-degree murder requires that he acted with what the law calls a depraved mind. I'm going to talk to you a little bit more about that in a minute. But manslaughter does not require that. It just requires that A, Adreian Payne is dead, which is stipulated to. Obviously, we've established that he is deceased, and that the second element is Lawrence Dority intentionally committed an act or acts that caused the death of Adreian Payne. Now, obviously, in this case, that act is taking his gun and intentionally shooting him. That's it for manslaughter. Now, you're going to see that for second-degree murder, there is an instruction regarding heat of passion. That doesn't apply to manslaughter. So the two things that you can consider for manslaughter for elements are that Adreian Payne is dead and that the defendant committed an intentional act that caused the death of Adreian Payne. We've proven manslaughter. We've met those elements, but you should not convict him of manslaughter because that's not the highest crime proven. So I want to talk about second-degree murder. I'm going to put it up here. I know you have it in your packets, but I want to talk about it in a little bit more detail. And if you can't read it exactly on the screen, again, I say you have it in your packet. It is on page 3 of your packets. But So there's the same, the first element is the same, that Adreian Payne is dead, and that the death was caused by the criminal act of Lawrence Dority. That criminal act is taking his firearm and shooting him while he's sitting in or by his car. The third element is the difference, that there was an unlawful killing of Adreian Payne by an act eminently dangerous to another, demonstrating a depraved mind without regard for human life. So, ladies and gentlemen, I pose to you that obviously taking a firearm and shooting another human being demonstrates a depraved mind, and eminently dangerous to another and depraved mind is defined for you. It says a person of ordinary judgment would reasonably certain to kill or do serious bodily injury. A normal person knows if you take a gun, you point it out, and you pull the trigger, it's going to cause bodily injury, or it's going to kill him. It's done from ill will, hatred, spite, or evil intent. And I want to point out that these are ors. So you can find that it was done from ill will. He was upset that he was outside his house. Hatred, maybe he was that mad that he was outside his house. Spite or evil intent. You can find any of those. You don't have to find all of them, but if any of those satisfy the depraved mind requirement. And he certainly had that, and his actions demonstrate that he had that. And then finally, is of such a nature that the act itself indicates an indifference to human life. And again, some of these things overlap with each other. Obviously, again, taking a firearm, pointing it, and shooting at another human being shows that you're indifferent to that person's life. Now, with second-degree murder, we do not have to prove an intent to cause death. So that's not something you consider. Maybe he just wanted to injure him or whatever the case may be, if that's what you believe. I think the facts show that he took deadly aim and intended exactly what happened, but you don't have to find that. You don't have to find an intent to cause death, just that he had an intent to shoot him. So then there's the portion that talks about the heat of passion. And there are some subsections here, A through E. But each of them talks about an ordinary, reasonable person. So it's not just, well, I was scared, so I did it. That's not sufficient for heat of passion under the law. It's not sufficient to say, I was upset, and so I did this thing, and I'm excused from it being second-degree murder. No. There must have been a sudden event that would have suspended the exercise of judgment in an ordinary, reasonable person. Again, that language, ordinary, reasonable person. And again, I want to point out too, all of these are ands. So you have to find all of them for these actions to be reasonable. A reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury. So the question is not just, was this defendant in a blind, unreasoning fury? He was certainly not acting reasonably, but would a reasonable person have acted that way? No. There was not a reasonable amount of time for a reasonable person to cool off. This defendant took time. He went in his house. There was no threat at that point. He wasn't pursued. He armed himself. He came back out. There was no further threat. He's being begged and pleaded with to not do what he did, but he still did it. So he certainly could have cooled off when he went in the house. And then another and also has to be met. A reasonable person would not have cooled off. So say he was so upset by whatever interaction that they had out by the victim's vehicle before he went in the house. A reasonable person, when they go in their house, can shut the door, can lock the door, can do whatever, can cool off, before coming out and doing what he did. And then finally, he was so provoked that he did not cool off before he committed the act that caused the death. So it's not just a matter of, I was scared, this was a scary situation, and therefore I did this and I should be excused of second-degree murder. No, you have to look at it based on a reasonable person. And the defendant in this case and his actions were anything but. So the defendant in this case, took the stand and claimed that he was acting in self-defense. He was justified in his use of deadly force. But that is not the case when you look at the facts. The defendant's actions were not reasonable. The judge has given you a lengthy definition of justifiable deadly force. That's on page 8 of your packet. And for something to be justified, it must be both an objective justification and subjective. And I want to go through a specific paragraph that is in your instructions that explains that and how that works and what you're to consider. The second from the bottom on this page, I don't know on your packet, but it starts with in deciding. So the judge has instructed you, and you're going to have this in your packet, in deciding whether Lawrence Dority was justified in the use or threatened use of deadly force, you must consider the circumstances at the time the force threat was used. So that's important because he didn't use the force, when they first had words and he decided to go in the house. This is after he had gone back in the house, had time to cool off, arm himself, and come back out. And other people, were present at this point, including Tara Walker. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant actually believed the use or threatened use of deadly force was necessary. So first of all, this wasn't threatened use of deadly force. I guess maybe it was in the moments just before he pulled the trigger, but this was deadly force. He did pull the trigger in this circumstance. And he himself must have actually believed in that moment that it was necessary to do what he did. Not that he wanted to, but that it was necessary. And beyond that, even if beyond just necessary in his mind, moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed that the use or threatened use of deadly force was necessary. A reasonably cautious and prudent person. This defendant's actions were not the actions of a reasonably cautious and prudent person. That's for you to decide when you look at the facts of the case and you look at the evidence, but the evidence has shown that what he did was not the actions of a reasonably cautious and prudent person. The defendant in this case was not standing his ground. He was the aggressor. He was the person that initially approached a car parked on the street. This person wasn't knocking, on his door, wasn't standing on his lawn. He was sitting in his car with the window rolled up. He was the one that made even an initial contact. This was not an act of defense, and it certainly wasn't an act of reasonable self-defense. He took a life not to protect his own or to protect his family. He took it because he wanted to, because he was upset. His actions show a depraved mind, and he's guilty of second-degree murder. We ask that you convict.
All right, defense.
Your Honor, maybe close more briefly.
Come on.
Hello, 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 hello. Right. Can you hear me now? Working? Is it working again? Oh, happy days, Terry. I'm glad you got the sweatshirt. I'm glad. Happy days. Thank you again for your support, my darling. Badaza, I was just saying, Badaza, thank you to you for the. I should have guessed that was you the PayPal. I guess after I said thank you, but thank you, Badaza, for the PayPal. Sorry, people, my mic was muted. I just wanted to say as well. If you pray or if you've got any religious beliefs, please pray up for J Mac today. She has an important day today for her cancer treatment. So I wish you all the luck in the world, J Mac. You know that I did message you privately, but you are in my thoughts today, my darling. I hope it goes okay for you. Fuck cancer, but let's go. So please, if you've got a moment, please pray for J Mac for today that today goes well. So love you, my darling. Hope it goes well for you. Um, Oh, I'm glad you love your sweatshirt. There you go. They are comfy. They are nice. Right, let me get this back now. Then, sorry, I'll get the thing back. Thank you, Mama Ames. Thank you, Mama Ames. There you go. Love you. Thank you, J Mac. Thank you, Genty. Thank you, Italian. There you go. Thank you, Dana. Right, here we go. Let's listen to this now. Then we got another 45 minutes max of this guy.
I don't have an objection.
Okay.
Good morning,
Counsel, for
cheating
defense, you may
Stacey.
proceed.
Yes, Your Honor. I'm just grabbing right now.
Spacey Stacey will pray for J Mac as well. Pray for J Mac that she has a good day for her cancer treatment today. All right.
Your Honor.
Oh my, is that Dana? Cardboard cutout.
Good morning, ladies and gentlemen. Good morning. I'm going to stay at the podium this morning because that I really want you guys to hear it.
Maybe you want to stand at the podium because I told you. Boom, boom, boom. You see that? You see that? My message yesterday worked because we couldn't hear, and he's now standing at the stage at podium. Let's go, people. The alternate corner. We sorted it out, people. Thank you to the court. Thank you very much. Thank you to the alternate corner. Thank you, all of you. Look at this. I told your ass, Bofo. I told you stand at the podium, and they all listened. Let's go.
I have to say. Let's forget all the antics, okay? You remember during jury selection, I said we was going to have a real conversation, right? Real conversation. And the state and I felt like you guys were the most suitable jurors after Verdire, okay? There's three sides to every story. I know you probably heard that before. One person's version of what happened, another person's version or perspective of what may have transpired. And then there's the truth, right? The truth, ladies and gentlemen, is you at this point. You determine what the truth, what the facts are in this case. You have the ability to give us justice here today. Okay? My opening statement, I explained to you all what you would hear in this case. And I submit to you that the defense kept its promise. Okay? We kept our promise in this case. This is a case about self-defense. This is a case about reasonable doubt. Now, the state has rested, defense has rested, and we both are asking you to use your God-given common sense. consider all the reasonable inferences that comes from the facts that you heard and saw today and throughout the scope of this trial. Consider what you heard, what you didn't hear, what you saw, what you didn't see. Use your common sense, okay? This case is not for the weak at heart. We selected you guys hoping that you wouldn't just have sympathy one way or the other, you know, just unbiased, impartial citizens. This is your highest civic duty to sit on the jury. This is literally the highest mode of citizenship you can have. Sitting right now and in judgment to decide whether someone should be found guilty for a crime that they've been accused of, and falsely accused of at that. Okay. I thought about this last night when I was summing up the evidence in this case, and a huge question just jumped out in my mind. And I already had been thinking about it throughout the scope of representing Mr. Dority, but after the trial, when the state actually presented and showed their hand, you know what that question was? Where's the proof? Where's the proof? The state has a burden, a high burden, that they have to overcome. And I submit to you, the state has not met their burden. They did not. It's not your job to stack inference upon inference upon inference to come to a conclusion that Mr. Dority did not act in self-defense. If you have a question in your mind right now, an unanswered question, if you have an unanswered question in your mind about the facts of this case, if something's not sitting right with you, if something's troubling you, if it's something that you would have wanted to see or needed to see to come to a conclusion and you can't make sense of why you didn't get that, why you didn't hear that, that's reasonable doubt.
Objection, misstatement of the law.
Sustained. I've given you what the instruction is on reasonable doubt. You have it in writing. You should consider that, not what the lawyers argue. Understood?
I'll go directly to the jury. The court has already given to you. And again, you guys use your common sense, okay? And I'll say this a little differently. Mr. Dority is not required to present any evidence or prove anything at all, number one, all right? That's not his job. He could have sat at that table, played tic-tac-toe. He could have been texting if the court would allow. Of course, court decorum doesn't allow that, but you get what I'm saying. He didn't have to do anything, okay? Proof beyond a reasonable doubt does not mean proof beyond all doubt. Of course not, all right? Reasonable doubt is not merely a possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. If you have an abiding conviction of guilt. On the other hand, this is what I want you to really pay attention to. If after carefully considering, comparing, and weighing all the evidence there's not an abiding conviction of guilt, or if you having a conviction is one that's not stable, one that wavers, vacillates, then the charge is not proved beyond a reasonable doubt. And guess what? You must find him not guilty. Not may. You must do it. So, nobody in this courtroom other than Mr. Dority, I don't know if Ms. Walker is in here, at some point, no one, neither of you, the court, myself, the state, was at 2529 Egret Shores Drive on May 9th, 2022, right? Everything we say is like our best efforts to try to advise you of what happened that morning around 1:30 a.m. It's a very serious case, ladies and gentlemen. And it's a sad fact that, unfortunately, it's a large sum of people who are murdered every year. And we ask you not to just base this case off that type of sympathy that someone lost his life. We will acknowledge this is a very sensitive, sad situation. Both families have been impacted. So out of respect for both families, this is a tragedy. But Mr. Dority didn't go looking for trouble. When tragedy happens, right, it becomes the duty of law enforcement to be competent, careful, timely, diligent in the performance of those duties, especially when investigating homicides and violent felonies, and doing it without a bias, without a rush to judgment. So let's talk a bit about what the evidence did show, right? The evidence revealed that neither Mr. Lawrence Dority or Lawrence Dority's fiancée, Tatiana Mesa, invited Mr. Payne over. You didn't hear from Tatiana. You didn't hear that from her mouth that she invited Tara over. Where's the text message? You remember that? Tara Walker wants you to believe she was texted by Miss Tatiana Mesa to come over. Did you see a text message? Where's the proof? The evidence showed that even Miss Tara Walker advised her boyfriend, Mr. Payne, not to go over to Mr. Dority's house. She admitted to that fact. But why? Why was he there? Why was she there? The crime scene was contaminated. And I'm going to expound upon that a little bit later. That's very important. It's so very important to this case, fatal to the state's case. It's fatal to the state's case. There was evidence that was not properly secured and processed. Tara Walker's testimony is not credible. There's inconsistency in the state's case. There's lack of evidence in the state's case. And when you go through the jury instructions, that is a factor that tends to go towards reasonable doubt. When there's inconsistency in the evidence, lack of evidence, inability of witnesses to recall what happened, you know, Mr. Dority's actions were justified under the circumstances of this case, ladies and gentlemen. Mr. Dority was standing his ground. Let's talk a little bit more about what you heard over the course of the trial, though. Now, in the opening, The state conceded that Mr. Dority and Mr. Payne had brief words, right? So all this badgering Mr. Dority on the stand about him allegedly telling a detective that he made no comment, that he just walked out the house and shot this man. Ladies and gentlemen, you heard it on the video that it was verbal. Not only that, Tara Walker, even though she didn't want to really say what happened, she said she pulls into the neighborhood, pulls up to the house, and sees her boyfriend standing outside the car, sees Lawrence Dority talking to him, and based on her words, communication was happening. Such a soft word, right? They was just communicating at 1:30 in the morning. Just communicating. That's not what happened. The state tried to create some sense of a factual inconsistency, knowing the fact of the matter is that the evidence revealed there was in fact a verbal altercation outside of Mr. Lawrence Doherty's home at 1:30 in the morning. And Mr. Payne's vehicle was outside of Mr. Doherty's house. Feel free to ask for a read back of the opening statement if you don't recall that.
Objection. The opening statement is not evidence.
Sustained.
The state made no mention of Mr. Payne's girlfriend being present during the initial altercation either, because she wasn't. Mr. Payne arrived before her. They didn't meet together. You remember? She was saying that at some point, she decided to text him and say, hey, I'm headed over to Tatiana's house. I don't know, something's going on, something. And he took it upon himself, I'm going to go over there too. I'll meet you there. No, don't go. No, I'm already on my way. I'm on the 4-8. I'm on my way. Don't even know where he stayed at. Driving around the neighborhood, cabins in the neighborhood, looking for my client's car. 1:30 in the morning. So at some point during the verbal altercation, Tara Walker arrives. Mr. Payne actually walks up to her car. And at some point she tells him to get back in the car and move his car up some more, closer to the house. But do you remember what Tara said? That when she first arrived, that the first person she talked to was Larry Doherty, Mr. Lawrence Doherty's father. And what did Mr. Larry Doherty say to her? Tara, get back. I'm about to go get my gun. Now, if it wasn't a threat that appeared imminent or of some sense of seriousness, that's consistent. Use your reasonable inferences. You're allowed to use reasonable inferences. So that's one fact that's admitted by the state's own witness. The state has proven the defense's case. When Tara Walker pulled up, Larry Doherty told her to get back. I'm about to get my gun. She said, no, don't do that. That's my son's father. That's my boyfriend. Oh, I've never seen him before. That's a big fella. How big is he? Wait a minute, let me see. Medical expert Dr. Hansen said he was 80 inches. Mr. Dority, could you stand up for a second? With your permission, Your Honor, may I ask my client to stand up, please?
That's all.
See what Mr. Payne was doing, he was coming to try to pick a fight. He was trying to be intimidating. He wasn't coming to sing a Christmas carol outside his house at 1:30 in the morning. He wasn't delivering for Uber. He wasn't delivering for Amazon. He had no right to come to his house. Now, if you believe he has a right to be in the street, just parked outside, just waiting, lying in wait for someone with your car running, headlights on, just sitting in the car, and then when someone walks up thinking that you're someone you know, you hop out with a threatening gesture. Mr. Dority goes in the house. A reasonable person, you know what a reasonable person would do after having an argument outside of someone's home that you don't have a right to be at 1:30 in the morning? And when that person gets ready to go in the house, after you threaten the person and he goes in the house, by the time he comes back out, you should be gone. But guess what? He moved up a little bit closer. And guess what? Mr. Dority's son was still outside, who was 9 years old at the time, 8 or 9, give or take. His dad was 62 years old. There's inconsistency in the evidence, ladies and gentlemen. There's lack of evidence in this case. So let's talk about Deputy Garrett Morris. He was very forthcoming and candid, professional. He arrived at the scene. You can see it his body camera. He rushed over, and basically he was administering life-saving measures to try to revive or try to just get some sense of keeping Mr. Payne viable till paramedics can arrive. You know, he arrived, he located Mr. Payne in the driver's seat at that time, one left foot out of the vehicle, right foot in the vehicle, you know, but he wasn't all in the car the whole time now. Only after this shot hit him and set him down, he went and got in the car. Because you remember, I was talking about Dr. Hansen. I don't want to jump around too much, but I'm going in the order of where the state called their witnesses. So just walk with me through this journey of justice real quick. Just walk with me for a second. Detective Garrett arrived, pulled Mr. Payne out of the car, and started trying to administer CPR. Okay. He did a brief search of Mr. Payne's fanny pack. He did not see any weapons in there, but he did not search the vehicle at all. Okay. That's pretty much all he did. After this, fire and rescue arrived, and then Deputy Garrett says he maintained the crime scene. Just himself, just Deputy Garrett maintained the crime scene. He testified that he put up crime scene tape, and he held the area around the car until homicide and forensics units arrived. Now, he was equipped with body camera footage, remember? Did you see if he maintained the area on that body camera footage that you saw? Where's the proof? Body camera's on. You on duty. You're working. See, the state is trying to cherry pick with you. They're picking to just try to show you some things, to try to spoon feed you. You ever had Thanksgiving dinner that was so nasty that you had to sprinkle a little sugar on it to make it taste good? That's what this tastes like. That's what this is. No, don't let them force feed you. If it's nasty, it's nasty. All right, let's proceed. The state published the body-worn camera footage, and the footage did not reveal that he maintained his area around the car. In fact, there is no evidence that the area around the car was even secured or maintained free of contamination or free of manipulation. Also, Deputy Garrett candidly admitted that when he arrived on the scene, the passenger side door of that black Chevy sedan, that Malibu, was already open. Now, he initially testified that he believed Tara Walker was on the passenger side, but then he couldn't really say that because the door is already open by the time he arrived. All right? And again, he did not search the interior of the vehicle. And I ask you again, where's the proof, right? Somebody gained access to the passenger compartment of the vehicle. That door was completely open. Tara did say at some point in her testimony that she went on the driver's side. I'll get to her testimony in a second. I'm just going to keep going down chronologically. But you know what else jumped out? And I hope you guys asked to watch that video again. If you listen closely to Deputy Garrett's body camera footage, Tara Walker is heard in the background saying, "Why am I here? Why am I here?" You said you was here because you was invited. Seemed more like a setup or something. What's going on? You know, Tara has a motive to not be honest in this situation, because you know what this is? When Mr. Dority arrived home and he approaches the vehicle that he was familiar with at one point, believing it to be Tara Walker, but unknown to him, a 6'8", 247-pound man steps out and in a threatening manner steps over to him and say, "I'll smoke you. What you want to do?" That's an aggravated assault with a weapon. That's a felony, a forcible felony. And if Tara Walker invited him over to do that, that means she conspired with Adreian Payne to commit a forcible felony of aggravated assault. Use reasonable inferences, ladies and gentlemen. So let's talk about Hannah Miner, the crime scene investigator. She, at the time of this incident, May 9th, 2022, she had only been employed, as a crime scene investigator for 4 months. She had just started January 2022. So she's 4 months in on the job, relatively inexperienced. And it technically shows, because the role of a crime scene investigator is to respond to the crime scenes, document the crime scenes with photos, notes, sometimes measurements, document evidence, collect evidence, process that evidence, package that evidence, forward that evidence to its final location, whether it's in a laboratory or evidence unit, and write reports of their involvement in those cases. And of course, they work in conjunction with law enforcement and detectives. This is her exact testimony, right? It's from my notes, right? But she failed to document and process, collect that knife. She didn't dust for prints. She testified that it can be done, and case by case it can be done. She didn't try to get any touch DNA. She testified that she can do that. It's case by case. So in a case like this, a homicide, an allegation, if someone died, that's not something where you think that's important to dust. She agreed that it can be a weapon. It is a weapon. But Tara is saying she's just been driving around with a kitchen knife for 4 months. A mother is not driving around with a kitchen knife on the front passenger side floorboard in plain view for 4 months. That's not believable. Well, one would hope or think. So May 9th, she was on the on-call crime scene investigator. Their office is short-staffed. They're only staffed to midnight. So any calls that come in after midnight goes to the on-call crime scene investigator, where they take the call from home. Miss Miner, investigator Miner, she didn't get notified till 4 a.m. This incident, Mr. Dority arrived at 1:30 in the morning, right? Do you remember the testimony of Tara Walker when she said her brother arrived at 2 a.m.? Follow this for a second. 1:30 in the morning, he gets home. 2 in the morning, Tara Walker's brother arrives. 3 in the morning, Tara Walker's father arrives. 4 in the morning, crime scene investigator is notified, and 5 in the morning, she arrives. 7 in the morning, Tara leaves with her car still at the scene. Crime scene investigator never took a picture of her car, never searched her car, didn't even know her car existed, although Tara was alleged to have been at the scene at the time of this incident. Nobody even took identification from her brother. What is her brother's name? Nobody knows. What kind of car he drive? Tara said a BMW. Crime scene contamination. You heard testimony from Mr. Dority that he seen her go in the car and run, and she didn't come back out until she was talking to law enforcement, till law enforcement arrived. But what time did law enforcement arrive? The only person you heard from was Deputy Garrett. Where was the other officers, if any? And what time did they get there? How could you secure a crime scene? Where's the proof? It's like, it's akin to someone throwing rocks at a glass window, and when you come outside to confront them, they're hiding their hands. Where's the proof? This is serious. This is someone's life. The state wants you to believe that my client just comes out the house guns blazing, just shooting at someone for no reason in cold blood, without adequate provocation, without it being in fear, just willy-nilly. Use your common sense. That's not what happened. And it's not the defense's job to show you things that is not even, it didn't happen. The video that the state showed you doesn't even show the actual, it doesn't show any body, any person in any frame. All you hear, it's a video of audio. It's a video of audio. They didn't. Well, how about this, if this don't convince you? When Mr. Dority testified in the defense rest, the state didn't even put on a rebuttal witness, no rebuttal evidence. They haven't rebutted self-defense. Their own case established self-defense, arguably. And after hearing from Mr. Dority, who refuted that? Tara wasn't there when he first encountered Mr. Payne. Now, I imagine what may be troubling you guys is that there was actually no gun found in the car. But it's a reasonable explanation for that. You know why there was no gun found? Because the gun that he had was removed. Either by Tara, her brother, or somebody.
Objection, facts not in evidence.
That's a reasonable inference.
Overruled.
You are allowed to make reasonable inferences based on the facts. That's her job, to collect and document the knife. It was still in the car, not taken in evidence at all. You didn't even have a chance to see it today. I couldn't present it to you. It was not taken into evidence. That's not fair. The state can strike hard blows, but they can commit fouls now. Mr. Payne's girlfriend, her car was on the scene. It was never searched, no picture taken or anything. Investigator Minor agreed that she did not document the vehicle. She wouldn't know what was inside the vehicle because she didn't document the vehicle. And she agreed that part of her duties were to collect evidence, and she failed to document or collect evidence. This means this was an incomplete investigation, insufficient investigation. Marco Quintana, the neighbor, had that Google Nest camera. He didn't see what happened. The actual altercation didn't occur in video, but you just had the audio. He basically just provided them with audio. Not much value to the case at all, other than just at least allowing you to see that an actual argument did happen. You can hear that something happened outside, and then you hear the gunshot. Mind you, Mr. Dority only fired one shot. It's not like he unloaded a clip. He shot to repel the threat. He didn't shoot to kill. He didn't ask for what happened. Even in the state's opening, he says that Tara Walker speaks with her boyfriend, and he decides to come over to the residence as backup. Backup? Backup for what? I hope that you guys, you have to base this case on the facts that you heard in court, not anything external. Not just, this is the case. The facts are the facts, and they didn't meet their burden. They didn't. Tara Walker says that Tatiana Mensah texted her and said, meet me at the house in 15 minutes. Did she meet you? Where was it? There was no meeting. It's not right, ladies and gentlemen. You are empowered with the ability to give us justice here today. Justice demands not guilty. His actions were justified. When you go through this jury instruction and look at the justifiable.
Erin Hatchie drives a bus, yellow bus, yellow bus. Erin Hatchie drives a bus all day long.
Use of deadly force instruction, all those elements are met. It's like, think about this. The elements, you think about elements of any type of crime or any type of rule of law. Think about a peanut butter and jelly sandwich, right? You got peanut butter, jelly, and bread. If you're only presented with bread and peanut butter with no jelly, then guess what? It's not a peanut butter and jelly sandwich. It's missing a necessary element. This is a very simple case. Very simple. Getting back to some of the comments, Mr. Payne, instead of leaving, pulls his car up closer to the home and gets back out of the car. Mr. Dority again questions, why are you here? You need to leave. You can't really hear much of the conversation. Like, it's muffled. It did happen relatively quickly. It happened relatively quickly, And you can see in that video that my client's son was very, very close in the vicinity to this situation. And it was not until Mr. Payne reached in a threatening manner as if he can pull. It just goes back to Dr. Hansen, right? Let's talk about her for a second. She has 35 years of experience, 35 years since 1990. She did maybe 250 to 300 autopsies a year for 35 years. And she testified that the trajectory of the bullet wound that Mr. Payne was inflicted with pierced the tissue of his bicep. Mr. Femur twisted it, just pierced it, and then it went into his chest cavity. But it's consistent with this movement. Thumb down, arms raised. How is this not consistent with someone trying to aim a firearm at you if you're left-handed? The testimony is he was left-handed. You can absolutely aim a gun. I apologize if I'm aiming at you like this, but I really need you to see this. A gun can be aimed like this. This is consistent. And just because the gun wasn't located, but you have a reasonable explanation for that. I can see if you didn't have that. I can see if the crime scene was not contaminated. I can see when law enforcement arrived, the passenger side door wasn't open, wide open. I could understand it if Miss Tara Walker's brother did not arrive at 2 a.m. before law enforcement did. Or at around the time of, had to be before, because he wasn't documented. Was he invited over? Who invited him? Sounds like an ambush. Seems like an ambush. That's a reasonable inference that can be made. Nonetheless, Mr. Dority reasonably believed that Mr. Payne had a firearm on his person. And there is a strong inference that there was. Either Tara's brother left with the gun, or Tara left with the gun, or the gun was left in her car, or her father took the gun, the crime scene was contaminated before law enforcement arrived there. Tara's testimony should be taken with a grain of salt at best. She didn't even want to acknowledge the fact that Mr. Payne arrived on scene before she did. Vacillating between that. Evasive. You remember when I asked her on cross-examination? Before Mr. Lawrence Dority walked away and went into his home, he actually asked Mr. Payne, "Why are you here?" Right? Tara Walker says, I can't recall if he said that. Can't recall. How convenient for you not to be able to recall that fact, but you can remember everything else, like the selective amnesia when a fact is not a fact in your favor. Come on. Reasonable doubt. Come on. How's this justice? How's this fair? Where's the integrity of this prosecution? Remember, the state had the burden to overcome. Remember that. There is so much wrong with this. The integrity of this prosecution cannot be established beyond a reasonable doubt. The state tried to impeach Mr. Dority about what he said to police, but they failed to show you the interrogation video.
Objection. Halliburton equally available for defense.
Sustained.
The burden is not on us. Did you hear that? The state wants us to provide you with evidence when it's their job to do that. You got to hold that against them. Throwing rocks at a glass window, hide your hands.
Judge can approach.
Yep.
Holy shit. That is, I don't know what I was going to say there. Yeah, lost my words. Let's go live. We're a bit behind. Yeah, hang on.
Rush to judgment here. Requires a finding of not guilty. He acted in self-defense of himself, his son, his father, given the darkness of the night, 1:30 in the morning, the size difference. He cooperated with law enforcement. Why was Mr. Payne there? Why was Tara Walker even there? This was a setup. Why didn't they leave? Mr. Dority was not intoxicated. There's no evidence of this. Mr. Dority's father drove him home because Mr. Dority's vehicle was in his own driveway. How else would he get home? Walk with his minor son at 1:30 in the morning? We're not challenging whether the firearm was functional or not. So FDLE testimony from Ms. Kristen Killinger, not an issue. Mr. Dority testified at 1:30 in the morning. He, his father, and his son was on the way home. As they arrived home, Lawrence sees a car parked in the corner of his home, and he automatically assumed it was Tara. So he thought it was weird that she was parked right there, because she would typically park in the driveway or in front of the house. So Lawrence walks over to greet her to say, "Hey," or inquire, why are you parked here? Mr. Payne gets out the car, and when he gets out, he's looking down at Lawrence. He has his hand in his waistband. Lawrence could see something silver sticking out on the side of his hip with his hand on it. And Lawrence asks him, "What are you doing here?" Mr. Payne replies, "This is the words from my notes. He actually said, 'I'm not playing with you, I'll smoke you.'" That's what he said. "I'm not playing with you, I'll smoke you." Lawrence replied by saying, "What?" Threw his hands up in the air, started freaking out. Lawrence's dad rolls down the window and asks, "Is everything okay?" Lawrence replied, "I don't know." He goes into the home, retrieves his firearm so he could safely get his son in the house. So he returns outside and sees Mr. Payne has moved his car up even closer, and he's gotten back out of the car again. this point, what do? It's dark. You have no duty to retreat, first of all. If it's troubling you that he didn't remain in the house and go hide in the closet and get on the cell phone and call the police, he's not required to do that. He's protecting his castle. He's protecting his son. He's worried about his father. Why are you here? Can you please leave? Mr. Dority is 5'8", 145 pounds, had no relationship or affiliation with Payne. Lawrence did not invite Payne over. Out of all the 15 years he known Tara, he had only met that man maybe twice. One time at some girlfriend's mother Thanksgiving or something like that, he showed up unannounced. And he couldn't even recall the other time he met him. Lawrence went back in his house because he felt like his life was threatened. The jury instructions, the law in the state of Florida supports self-defense in this case. This is one for the books. You have the ability to send a message.
Objection, improper, asking of a jury to send a message.
Sustained.
Ladies and gentlemen, we trust you will render justice and make the best decision, one that is fair, one that justice requires. Lawrence was just trying to go home. Lawrence didn't know what Mr. Payne's mental state or his motives. He knew what was going on.
Counsel, your 45 minutes that you imposed on yourself is up. You need to wrap it up. You started at 9:55. It's 10:40.
Thank you, Your Honor. Ladies and gentlemen, we trust that you would do your job today and find Mr. Dority not guilty, because that's what justice requires. There was no rebuttable evidence. Not guilty. Thank you.
State wish to give its rebuttal?
Yes, Your Honor. Have a moment to set up. I don't need the lights off just yet. I gotta get the lights set up. Thanks. Said in their closing argument was that you should use your common sense. And the state wholeheartedly agrees with that. Use your common sense. We don't ask anybody to check their common sense at the door. The facts in this case, if you look at it using your common sense, you'll see that this defendant wasn't acting like a reasonably prudent person. Now, opposing counsel stated correctly, the state has a high burden in this case. We have a burden of proving this case beyond a reasonable doubt. And that's our burden in every criminal case. Same as a murder case versus a driver's license case, it's the same burden. When we were in jury selection, we obviously hadn't met that burden. The question was asked, I believe somebody, if you had to give a verdict right now, what would it be? Obviously, you heard no evidence, be not guilty. Opening statements aren't evidence. So anything you heard after opening statement, if you had to give a verdict at that point and deliberate, it should be not guilty. But as evidence comes out in this case, that cloak of innocence is stripped away and has been stripped away from this defendant in this case. And with the evidence that's here and the evidence that you heard on that stand, he now sits before you a proven guilty man. So, we do have to meet the elements in this case. And opposing counsel talked about a peanut butter and jelly sandwich, right? So have a peanut butter and jelly sandwich, you got to have the bread, you got to have the peanut butter, and you got to have the jelly. Those are the three elements. So, a pretty good analogy to the elements in this case. For manslaughter, there's just, the two elements that we talked about, then the three elements for second-degree murder. And that's what we've got to prove. We've got to prove each of those elements beyond a reasonable doubt. But opposing counsel also said in his argument that if you have any questions or any questions about any of the facts in the case, then that's a reason to find the defendant not guilty. That's not true. That's not correct. We have to prove the elements beyond a reasonable doubt. But if you're going back there and you're wondering, well, I have a question whether the victim's car was gray or black. I don't think the state established that. Well, that's not an element. We don't have to prove that. So if you have a question of whether the car was gray or black or something like that that's not an element, that shouldn't influence your verdict. We have to prove the elements beyond a reasonable doubt, and we've done that here. We've made the peanut butter and jelly sandwich, as opposing counsel talked about, because we've hit those three elements for second-degree murder. Opposing counsel talked about a text message that you didn't see the actual text message that Tara Walker, talked about. Okay, I mean, you can believe what you want. Obviously, weigh the credibility of the evidence, but she showed up there. You can use your inference, as opposing counsel said. Why was she there? Right? She said it was because she got a text message. All right, you can decide if that makes sense. Opposing counsel talked a lot about the crime scene being contaminated, but how? You didn't hear anything in the testimony, the evidence of how it was actually contaminated. They infer that somehow maybe with no evidence that the gun was present and was taken. But there was nothing that you heard. Nobody testified to that. None of the evidence you heard showed that. They talked about, Corporal Morris, the first person that arrived on scene. Yeah, he didn't search the vehicle because the first response was to try to save a life because of the actions of this defendant. And his priority at that moment wasn't to secure the vehicle that he was, right next to. And you can see, that he was there the entire time, that the defendant's father was there, that Tara Walker was there. And she was, by the way, hysterical this entire time. From the moment that this defendant shot the victim in this case, and she runs to the neighbor's house to when law enforcement responds, and you can see on Corporal Morris's body cam, she is hysterical. Is this a person that's in that moment just beside herself? She's gonna take a gun or something and try to hide it somewhere? Ladies and gentlemen, in your instruction, it talks about beyond a reasonable doubt, but it also talks about what's not beyond a reasonable doubt. It's not a possible doubt, imaginary of what could have happened with this gun that was never there, speculative, forced doubt. That's what that is. It's imaginary. It's speculative. Now, opposing counsel talked about the height difference between the defendant and the victim. And yes, the victim was tall. He was, 6'8". But this, and you can consider the relative height, but this wasn't a fist fight. This wasn't even something at the time that the shooting happened where they were in arm's reach of each other. It doesn't matter how tall you are when the other person has a gun. And yeah, if the victim and him were engaged in a fist fight, maybe he feels the need to bring a gun out to defend himself at that point. That's not what happened. That's not the facts of this case. So the fact that he's 6'8" doesn't have any bearing on whether his actions were reasonable. They weren't reasonable. Also, opposing counsel talked about, Adreian Payne should have left. Maybe he should have. None of us were there, but there's one person on trial today, and that is this defendant, not Adreian Payne. He's not here today because the defendant acted in the action that he did, and he killed him. That's why. Now, opposing counsel talked about the defendant's son and father being present, but the defendant even acknowledged in his own testimony, begrudgingly, that there were no threats made to his son, there were no threats made to his father, who wasn't protecting them from some sort of threat from the victim in this case. This is a point that I really wanted to address from opposing counsel's argument. He talks about, if you go back and you listen to the body cam from Corporal Morris, you'll hear Tara Walker say, "Why am I here?" It's not like, why am I here? Like this, and like that's some big conspiracy. I encourage you to listen to that body camera. She is hysterical, and she's standing there, and she's asking, "Why am I here as I watch the father of my child be murdered? Why am I here for that? Why am I living through that?" And there's one reason that she was the defendant. Now, there's a lot talked about by opposing counsel about the knife, the kitchen knife that was found in the passenger seat of the vehicle, and why that wasn't collected. Well, this wasn't alleged to be a stabbing case. There was no allegation that anyone was stabbed or that the knife was used. Also, the defendant, in his testimony yesterday, got on the stand and said he saw this silver object. But when I asked him, "Did you say that in your interview with law enforcement?" "Well, I don't know. It'd been a while." This is right after it happened. He didn't say it then, but he said it yesterday. Why? Because he got to hear all the evidence in the case, and he got to craft his testimony in a way to try to make it seem justifiable what he did. But even by his own words, he couldn't quite wrap it around the requirements of the law. Because even by his own words, what he did was not justified. Now, opposing counsel is right that when he first had his words, or whatever the case was with the victim in this case, and he went in his house, he was not required to call 911. That's true. He's not required to do that. He's not required to cower or anything like that. But that doesn't mean that because he's not required to do that, that somehow that makes his actions justified. He has to meet the requirements of the law that we talked about previously, that his actions were something that a reasonably prudent person would do. Just because he didn't have to call 911 doesn't mean his actions of arming himself with a gun, coming out and shooting a person that's not an armed creature of him, not on his property, not armed, is reasonable. So yeah, he didn't have to call the police, but he was not justified in doing what he did. So, opposing counsel talks about defending the castle, defending his home. Again, I want to emphasize to you that the victim in this case never set foot at his house, never knocked on his door, never stepped in his driveway, didn't park in his driveway, didn't park in front of his house, didn't step on his grass. He wasn't defending his castle. He saw a vehicle that he recognized. He went over there at 1:30 a.m., had the person roll the window down, and that's what started the engagement between the two. He did that. He's not defending his castle. And then he went back in, armed himself, and came back and shot the person in his car on the street. So he's guilty. Now I'm going to play for you the clip that shows the audio and then Tara Walker running afterwards. And you can hear for yourself. You can't see it, but the audio paints a picture. Don't pull your gun out. You have to come here. Pleading with you. Do not pull your gun out. Do not pull your gun out. You asked to come here, Lawrence. Notice what you don't hear there. You don't hear anybody yelling, Adreian, put your gun away. Adreian, don't pull your gun out. Adreian, no. You know why you didn't hear that? Because he was the aggressor. He's the one that pulled his gun out. He was the only person making a threat, and he's the person that's guilty of second-degree murder. The state asks that you find him guilty as charged, and you find all of the firearms enhancements that are on the verdict form that you're going to get. Thank you.
All right, ladies and gentlemen, we'll resume with the remainder of the jury's instructions beginning on page 13, starting with rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence in these instructions. 3, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. 4, remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5, your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think that I prefer one verdict over another. You may find the defendant guilty as charged in the information or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you, and I will go over with them with you at this time. The first one is the actual verdict, and then there are 4 special findings that you'll have to make with respect to the firearm, okay? Each of them has a caption. That's the top portion, and it just indicates that it's the case of the state of Florida versus Lawrence Alexander Dority. It has the charge, the division number, which is assigned to this courtroom, and the case number that's assigned to it, and then it indicates that it is in the Ninth Circuit here in Orange County. The verdict form gives you three options. The first option is we, the jury, find the defendant guilty of second-degree murder as charged in the information. The second option is we, the jury, find the defendant guilty of included offense of manslaughter. And the third option is we, the jury, find the defendant not guilty. The bottom portion of all the forms is the same. It says, "So say we all," dated at Orlando, Orange County, Florida, on this blank day of July 2025, and there is a place for the foreperson to sign. When you all have reached your verdict, whoever your foreperson is that you've elected needs to do three things on the verdict form for me. You need to check one of the three options: guilty of second-degree murder, guilty of manslaughter, or not guilty, one of those three. You need to make sure that you fill in the date, and you need to make sure that you sign the verdict form, okay? You'll need to make sure that you do all three of those things, otherwise the verdict form is not complete. If you don't do those things and you come back and I see that the verdict form is not complete, I'm required to send you back in the jury room, and I can't tell you why I'm sending you back in the jury room. So I'm telling you why now, okay? So just make sure we get those three things done. In the event that there is a verdict on either second-degree murder or manslaughter, then you have to do the special findings. If you find him not guilty, then you don't need to make any special findings, okay? The special findings, there are four of them. The first special finding says that if you find the defendant guilty of second-degree murder, you then answer this question. We, the jury, find the defendant did, during the commission of the crime, actually possess a firearm. The second option is we, the jury, find that the defendant did not, during the commission of the crime, actually possess a firearm. So special finding number one is only required if there's a manslaughter, if there's a second-degree murder verdict from you all, okay? And so then on this special finding, you would do the same thing. You would select either he did possess a firearm or he did not possess a firearm. Make sure the foreperson dates it and signs it, okay? The second special finding also applies only to a verdict for second-degree murder. And it says that if you find the defendant guilty of second-degree murder, you must then answer the following question. And there's two options. We, the jury, find the defendant did, during the commission of the crime, discharge a firearm. Second option is we, the jury, find the defendant did not, during the commission of the crime, discharge a firearm. As you did with the other verdict forms, the foreperson will select one of those two options, date it, and sign it. And then the third special finding also applies only to the second-degree murder verdict, if there is one. And it says that if you find the defendant guilty of second-degree murder, then you must answer the following question. And again, you have two options. We, the jury, find the defendant did, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. And the second option is we, the jury, find the defendant did not, during the commission of the crime, due to the discharge of a firearm, cause death to Adreian Payne. As you did with the other ones, you would select one of those two options, date it, and sign it. And then the last, fourth special finding applies to a verdict of second-degree murder or manslaughter. So if you have any verdict on those two charges or those two counts, that count or the lesser included, then you would have to do this finding. And it says, if you find the defendant guilty of second-degree murder or manslaughter, you must answer the following question. The two options are, we, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. Second option is we, the jury, do not find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. As with all the other forms, the foreperson will select one of those two options, date it, and then sign it. Once you have properly dated and signed and filled out the options for all of the verdict forms that are required, knock on the door, let us know that you reached a verdict, and we'll bring you in to take it at that time, okay? Now, in just a few minutes, you will be taken to the jury room by the court deputy. The first thing that you all should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your deliberations are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict, and to bring the verdict forms back to the courtroom when you retire or when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You're not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputy. Many of you have had cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. The deputies, and it cut off, the deputies will collect them before you go in. They'll give them back to you when you get out. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I'm going to talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The majority of these exhibits will be sent to you with you into the jury room when you begin to deliberate. The exceptions to that are, obviously, we're not sending a firearm back into the jury room. If you would like to see the firearm, write me a note saying that you'd like to do that. We'll bring you back in and we can show you the firearm. Okay. The other exceptions, do you have a device that is approved?
I do.
To go back into the jury room? Have you confirmed it?
I have not.
Assuming the parties are in agreement, then we can send back a computer that doesn't have access to the internet or anything to allow you to do research. It'll simply allow you to play the videos that have been placed into evidence. If that's the case, then I can send those back into the jury room with you. So I just need to know from you all.
Okay, so the laptop does need to be plugged in to work. It's an older laptop.
Okay. So it doesn't have a battery either, so you got to old school plug it in the wall. Okay. All right. Any objections?
No objection.
All right. So all the other evidence will go back with you so that you can take your time, use the computer that's provided to review the exhibits that require the use of the computer. The only exception is I'm going to leave the firearm in here. If you want to see it, let me know by sending me a note. Okay. All right, in closing, let me remind you that it is important that you are to follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Any objections to the jury instructions as read by the state?
None from the state, Your Honor.
Defense?
No, Your Honor.
All right. We had 2 of you that were selected as alternates. So if those 2 of you would remain seated, the remaining 6 of you can go back and deliberate your verdict at this point. And badge number 6.
Okay, so 6.
You were our alternates. We select alternates in the event somebody gets sick. Everybody else is healthy. So this will conclude your all's jury service. If you 2 will just remain seated there, I'll give you some further instructions. The remaining 6 of you at this time may take your notes in the jury instructions and head back to the jury room to deliberate. And they've already gotten their orders. Okay, thank you. All right.
All right.
Go ahead and hand them these. All right, go and have a seat.
Start the 11:08.
All right, gentlemen, you all were selected, as I indicated, as the alternates in the case. Whenever we have a case that's going to go more than a day or 2, we will select alternates because life happens, things happen. Had somebody had an illness, a family emergency or something, and they had to be replaced, one of the 2 of you would have been asked to step in. Fortunately, it looks like the remaining 6 jurors are all healthy, and so they will be doing the deliberations in the case. I know that jury service is an inconvenience. I know that it is an imposition on your time, but it is a very important part of our system of justice and a very important part of American citizenship. And for giving of your time the last 2 or 3 days, I do wish to sincerely thank you. You will not be called for jury service for at least another year, if that's any solace for you. But with that said, this will conclude your jury service. Do either of the two of you need an excuse for the last 3 days? Okay, if you could generate one, I'll have the clerk generate that. You already got it? Yep, all right, so she's already generated it for you. With that said, with my sincere thanks, you are excused from jury service at this time. Okay. Have both the state and defense agreed to all the evidence the deputy's taken back?
State's in agreement.
Okay. All right,
Right.
go ahead and have a seat.
Erin Ha is in the house, everybody.
All right, Mr. Dority, you have been present for the entire trial, correct?
Yes, sir.
All right. And you've had an opportunity to provide your input to your attorney at all the important stages and the various stages of this trial? All right. And I know we've talked.
Ole, 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 ole. Erin Ha, ole. Erin Ha, ole. Let's go, Erin Ha, ole. Erin Ha, ole. J-Mac loves a BJ, she says as well. So
Talked about them, but we talked about the witnesses that were called. We talked about the jurors that were picked. We talked about some of the strategy that you and your attorney have made during the course of this proceeding. Have you been satisfied with your attorney's representation of you? All right. Has he done everything that you wanted him to do? Was there anything that he didn't do that you wanted him to do? All right. So is it fair to say at this point that you're completely satisfied with his services? Okay. Anything further from the state at this point?
Nothing further from the state.
Defense? All right. We will be in recess
No.
at this point pending a question or a verdict.
no wicked side.
If you're going to leave, just ask that you give your cell phone number to the trial clerk so that we have ability to get a hold of you and that you remain within 10 or 15 minutes of the courthouse so that we can get you here, okay? All right, we'll be in recess.
So just so you know, J Mac's husband's initials is BJ, just in case. She loves him so much, she married one. Right, so nothing happened there. That was, jeepers. Yeah. So we've got, let's look at the verdict slip here. So 56% think murder 2, 30% think manslaughter, 15% say not guilty. So overall, quite a bit. 85% think he's going to be found guilty of something. So yeah, what I'll do is put another one in for you. There's mother is we're going to do. We're gonna do another poll quickly here. I can't even think what I'm doing. Poll. Start a poll. When will we get a verdict this afternoon? Noon. Later today, because they can go on late, so it'll be I'll say before 4 p.m. tomorrow. Star poll. Yes, for sure. Right, so there you go with us for that. I'll be keeping an eye out for some of this stuff. No verdict yet. What I'm saying is there will be. When are we going to get at the verdict? There's no verdict yet. No. I will put this to the side. So what I'll do is put this in. Hang on, let me just do this. Okay, I'll put this in another tab, and what I'll do is we'll have that play in here. Then what I'm going to do is play something here for you. That is a little bit. So this is something I was going to do yesterday for you guys, but we didn't get the chance because we went to this trial instead. So let me remove that. This is another trial that happened. So what I'm going to do is play you the. Oh shit! Sugar and spice is all things nice. Where'd that go? There. You pull that down. This is down. Wrong one. Right, hang on. Where's it gone? Here we go. This is a trial that happened, I think, 4 years ago. So, so you get to see this one. We'll play this whilst we're on Verdict Watch. So this is I got a background for you. I've then got opening arguments. Then I got a verdict, and then we got the sentencing. Just something to play if you're interested in watching it. So let me put it on for you. If you're interested to watch it. If you're not, that's fine as well. Here we go. It's a guy from Adam Coy. This will give you the background of what it is.
First to report the indictment and has reaction from Coy's attorney. Former Columbus police officer Adam Coy will spend the night here in jail after hearing 2 days worth of evidence. A Franklin County grand jury indicted him on murder.
But let me be clear that I believe the evidence in this case supports the indictment, and my office will vigorously prosecute this case.
On December 22nd, now former Columbus police officer Adam Coy was called to a home on Oberlin Drive for a non-emergency complaint about a vehicle running on and off. That's when Coy spotted 47-year-old Andre Hill inside a garage. Hill held up a cell phone in one hand. Another officer on scene told investigators Coy yelled "gun" before firing, striking and killing Hill. Hill was unarmed. The Ohio Bureau of Criminal Investigation is investigating the fatal shooting, and Attorney General Dave Yost office has been appointed as a special prosecutor in the case.
The vast virtue of law enforcement is diminished by the very few bad actors among its ranks, and only by holding a bad actor accountable can that virtue be sustained.
Mark Collins represents Coy and says he brought Coy to the sheriff's office this afternoon to be taken into custody.
Did you expect this?
Expected the indictment, absolutely. With the grand jury, there are no rules in there. The grand jury is only from the prosecutorial side.
Coy was fired from the Columbus Division of Police, and Collins says Coy has been cooperating with investigators.
Our client gave a long written statement. Our client gave a little over a 2 hour, 15-minute interview, and the BCI agents were very professional and very thorough. And so, we look forward to presenting our defense.
Asked if he will request a change of venue, Collins says that is something he is considering.
The reality of the situation, Lacey, is that these things are national news now, and it's everywhere that's covered. And with technology and social media, that the concept is difficult to potentially seat a fair and impartial jury, but it can be done.
Coy is expected to be arraigned later this week. In Columbus, Lacey Crisp, 10 TV News. And reaction to this indictment is pouring in tonight from all over Columbus.
10 TV's Richard Solomon spoke with city leaders on this decision. He joins us live tonight with that. Richard.
Well, Yolanda, Andrew, so many raw emotions going into the indictment of Adam Coy tonight. In fact, City Council President Shannon Hardin says this does show that true justice is being served. But he reiterated to me that this is only showing partial justice.
Even though we have an indictment, we still have to have a conviction. And even with conviction, Mr. Andre Hill will still not be with his family.
Hardin says he called for the arrest of Coy immediately after he saw the video. He told me the murder of Andre Hill showed him and everyone else in Columbus that there's still so much work to do to reshape policing. Remember, just a few days ago, city council members voted unanimously to pass Andre's Law. That law allowing disciplinary actions to come for officers who failed to render aid, for people shot or injured by police, and failed to turn on body-worn cameras. But guys, it's the fact that we have to have this conversation. The fact that another unarmed black man was killed by bad policing. That's why Hardin is saying more work still needs to be done.
Andre Hill is not here. Like, we should not even be having this conversation. I'm angry. I just don't want us to spike the ball here.
Now, Mayor Ginther also released a statement tonight saying this is a step towards justice. Reporting live in downtown Columbus, Richard Solomon, 10 TV News. Back to you.
Thank you, Richard. Well, tonight we're also hearing from Michael Wright, one of the attorneys for the Hill family. And their initial reaction is they're pleased and somewhat surprised murder was one of the charges.
We are happy that this first step did occur, but again, this is just a first step. I mean, we were a long way away from, having a conviction of Officer Coy.
The Hill family's main attorney, Ben Crump, and the family are holding a news conference tomorrow morning at 11. We plan to stream that live on our website and on the 10 TV Facebook page.
Okay, so that gives you the gist of the case. This is opening statements for the case, just so you can get a little bit of basis on it, and then we'll get into the verdict after that. But here we go.
Honor, counsel, ladies and gentlemen of the jury. December 22nd, 2020 was a cold night in Columbus, Ohio. That night, Andre Hill drove to 1062 Oberlin Drive in Franklin County, Columbus, Ohio, to meet with Destiny, a woman who he knew who lived at that address at 1062 Oberlin Drive. Andre drove a silver-colored SUV to Oberlin Drive. The SUV belonged to his boss. Andre had been using the vehicle to work a job while his boss was out of town. The SUV was what many would consider to be a work truck, a work vehicle that was filled with tools and equipment. When Andre Hill arrived at Oberlin Drive, he parked the vehicle on the street near 1054 Oberlin Drive and waited for Destiny to come out to meet him. Because it was cold, Andre was periodically turning the vehicle off and on to stay warm over a period of a couple of hours while he waited. The periodic stopping and starting of the vehicle engine attracted the attention of a neighbor. It attracted the attention of the resident at 1054 Oberlin Drive. His name is Robert Ronker. Mr. Ronker was disturbed by the noise, the stopping and starting of the engine. So he contacted police to report it and was advised that an officer would be out to check on the situation. Mr. Ronker made that call just before 1:30 in the morning on December 22nd, 2020. As a result of that call, Officer Adam Coy was dispatched to Oberlin Drive. Upon arrival, Officer Coy was initially investigating a vehicle that was parked in front of Mr. Ronker's residence at 1054 Oberlin Drive. However, Mr. Ronker noticed that Officer Coy was looking at the wrong vehicle. So Mr. Ronker came out, approached Officer Coy to advise him that the vehicle in question had actually moved up the street and was now parked along the side of the street at 1070 Oberlin Drive. Officer Coy then moved his cruiser closer to the location where that vehicle was parked. Andre Hill was inside that vehicle. Officer Coy had a brief conversation with Andre Hill while Andre Hill remained in the vehicle. During that conversation, Andre Hill advised Officer Coy that he was waiting for someone, and he showed Officer Coy a text message from his phone that said, "I'll be right out," or words to that effect. Officer Coy then told Andre Hill that was fine, and he returned to his cruiser to wait for Andre Hill to leave. Around that time, a second officer, Officer Amy Detweiler, arrived on the scene. Officer Detweiler and Officer Coy had a very, very brief exchange about the situation and determined that they needed to approach Andre Hill, who had actually just entered the garage of the residence at 1062 Oberlin Drive, that the residence where he was waiting on that person to come out. Now, here we have a photograph of that garage. At this point, Officer Coy and Officer Detweiler made their way up the driveway of 1062 Oberlin Drive towards the garage where Andre Hill was inside the garage. Officer Coy ordered Andre Hill to come out of the garage. Andre Hill began to comply with Officer Coy's orders and began to move towards the open garage door. He moved alongside a white car that was parked in that garage. Andre Hill had a cell phone in his left hand, which he had raised up towards the officers as if to show them something on the phone. His right hand was not visible. After Andre Hill rounded the bumper, the rear bumper of the white car, Officer Coy yelled "gun" and shot Andre Hill 4 times, killing him. The evidence will show that Andre Hill was not armed. He did not have a firearm. When the crime scene was processed, BCI agent Asia Chung recovered items at the scene, including a cell phone, including keys in the area where Andre Hill was shot, but there was no firearm. You will hear from a number of witnesses in this case there. You'll have the opportunity to view body-worn camera of Officer Detweiler, as well as body-worn camera of Officer Coy. Keep in mind, as you're viewing this, that the officer's body-worn camera was not on during their initial approach. So there are some portions of the events that were either not captured on video or that were captured without sound due to a feature on the body-worn camera that records the 60 seconds of video prior to the body cam being turned on, but records it without sound. In addition to viewing the body-worn camera, you'll also hear from Robert Ronker, the 911 caller, as well as other witnesses. Adam Coy has been indicted for 3 crimes. Those crimes include the crime for killing Andre Hill, a crime for felonious assault, and crime for reckless homicide. Let's run through what each of those entail. The first one, causing the death of Andre Hill. The state of Ohio has to prove beyond a reasonable doubt all the elements of these three offenses. What does the state of Ohio expect to prove? That the defendant, Adam Coy, caused the death of Andre Hill as a proximate result of committing or attempting to commit felonious assault, which is an offense of violence of the first or second degree. That's the first offense. Now, as part of that, the state has to prove that the defendant, Adam Coy, acted knowingly in causing the death of Andre Hill. What is knowingly? A person acts knowingly, regardless of purpose, when the person is aware that his conduct will probably be of a certain nature or a certain result. A person has knowledge of circumstances when he is aware such circumstances probably exist. Because you cannot look into the mind of another, knowledge is determined from all of the facts and circumstances in evidence. This is that mental element that the state will have to prove. The second crime, which the state has to prove beyond a reasonable doubt was committed by Adam Coy, is felonious assault. What's felonious assault? What does the state have to prove? The state expects to prove that the defendant, Adam Coy, knowingly caused serious physical harm to Andre Hill, or alternatively, that Adam Coy caused or attempted to cause physical harm to Andre Hill by means of a deadly weapon. That's the second offense. The third offense is reckless homicide. The state has to prove beyond a reasonable doubt that the defendant, Adam Coy, recklessly caused the death of Andre Hill. And here we have a definition of recklessly, that mental element that we've been talking about. In order to prove recklessly, the state has to show a person acts recklessly when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk that that person's conduct is likely to cause a certain result or be of a certain nature. A person is reckless when, with heedless indifference to the consequences, that person disregards a substantial and unjustifiable risk that such circumstances are likely to exist. The state of Ohio expects that at the end of this case, it will have proven to you beyond a reasonable doubt that the defendant, Adam Coy, is guilty of all three of those crimes. Now, the state also expects that the defense will assert that Adam Coy's use of deadly force against Andre Hill was reasonable and lawful in his official capacity as a police officer, and thus the state expects he will submit that he was justified in his actions. The defense will have an opportunity to present evidence to establish that defense called justification. In order to establish justification, the defendant, Adam Coy, has to prove that he was justified in using deadly force by a preponderance of the evidence. The state then has an opportunity to refute Officer Coy's use of deadly force was reasonable or justified. In order to do that, the state expects to call an expert witness, Seth Stoughton, to testify regarding national police practices, and the state expects that that expert will opine that Adam Coy did not act within those practices. Let's run through the justification, defense, and reasonableness. The standard for determining whether or not the use of deadly force by a police officer is justified is a reasonableness standard. If the officer reasonably believes deadly force is necessary to defend himself from the actual use of force or from the imminent use of physical force by a suspect that poses a threat of death or serious physical harm to the officer or others, then the officer's use of deadly force is not unreasonable. Keep in mind, reasonableness requires careful attention to the facts and circumstances. The reasonableness standard of a particular use of force must be judged by the perspective of a reasonable officer on the scene, not with the 2020 vision of hindsight. The standard of proof for proving that justification defense is a preponderance of the evidence. That's the slightly more than 50% standard that you've heard about in voir dire. So in order to prove that he was justified in using deadly force, the defendant, Adam Coy, must prove that he was justified by a preponderance of the evidence. The preponderance of the evidence is the greater weight of evidence. It is evidence that you, as jurors, believe because it outweighs the evidence that is opposed to it. A preponderance means evidence that is more probable, more persuasive, or of greater probative value. It is the quality of the evidence that must be weighed. If the weight of the evidence is equally balanced, or if you as jurors are unable to determine which side of the issue has proven the preponderance, then the defendant, Adam Coy, has not established the defense of justification. The defendant, Adam Coy, may call his own expert witness to give an opinion about the events that occurred that night on December 22nd, 2020. And that expert may give an opinion as to whether or not Officer Coy's actions were justified. In addition to the opinions of any defense experts, you may also hear evidence related to Adam Coy's version of events that took place that night. The state of Ohio asks you to listen carefully to that information, to critically examine and analyze all of that information. This is something that you'll likely circle back to at a later point. Ultimately, ladies and gentlemen, the determination as to what happened that night and whether Officer Adam Coy's actions were reasonable or justified will be up to you. At the end of this case, the state of Ohio will ask you to find that Officer Coy's use of force was not reasonable, that Andre Hill followed the commands of Officer Coy, that Andre Hill was not a threat to Officer Coy or Officer Detweiler, that Andre Hill did not have a weapon, that Officer Coy's actions were not reasonable under the circumstances, and that Officer Coy was not justified in shooting and killing Andre Hill. At the end of this case, the state of Ohio will ask you to find Officer Adam Coy guilty of all three of the offenses with which he has been charged. Thank you.
Thank you, Ms. Hamlin. All right, on behalf of the defendant.
Thank you, Your Honor. May I proceed?
You may.
May it please the court, Mr. Collins, Mr. Coy, Mr. Pearson, and Ms. Hamlin. Good morning, ladies and gentlemen. The state of Ohio just told you that Adam Coy did not perceive a threat on December 22nd, 2020. The state's own witnesses will tell you that the fact that there was no weapon found on the scene does not matter, contradicting the state's theory. You are going to hear that officers do not have to wait until they see the glint of steel. That what matters is how the hand was being presented, because an action is faster than a reaction. The state's own witnesses are going to tell you that. You are going to hear that that is how officers are trained. You are going to hear from the state's own witnesses that actual possession of a weapon is irrelevant, that police officers are allowed to be mistaken. Whether you agree with that or disagree with that, that is what their training says. You are going to hear from the state's own witnesses that Adam Coy does not have to await the glint of steel in order to use deadly force. Now, you will hear that Adam Coy saw that glint of steel, make no mistake. He saw a glint of steel. He saw metal come up in a hand. And the state's own witnesses will tell you that police officers do not have to wait. They don't have to be 100% certain that that glint of steel that's coming at them is in fact a firearm. So we ask that you keep that in mind as you hold the state of Ohio to their burden and examine the credibility of the state of Ohio's case. You are going to hear that on December 22nd, 2020, my client believed he was going to get shot. He yells, "Gun, gun," steps off the line, draws his weapon, and fires at what he honestly believed was a revolver being leveled at his direction. You are going to hear that he was mistaken, that it was not a revolver, but instead, that glint of steel turned out to be a metal mass of keys. You are going to hear that police officers are allowed to be mistaken, and you are going to hear, ladies and gentlemen, that even though there was no weapon found, his action to respond with deadly force was consistent with national police procedures. And that is what the evidence will show. Now, opening statements. Just as the judge indicated, they're an opportunity for each side to lead you down a path of what each side believes the evidence will show. Or is, as the case here, it's an opportunity for me to lead you down a path of what we believe the evidence will not show. For instance, the state of Ohio just tried to tell you that our client was reckless when he made the split-second decision to use deadly force. However, ladies and gentlemen, the evidence will show that our client was not reckless. He did what he was trained to do. And what he was trained to do was shoot to stop the threat. The evidence will show he didn't act with heedless indifference. He didn't empty his clip. He was a trained officer doing what he was trained to do, to stop the hand with what he believed was a revolver being leveled at his direction. Now, every time Mr. Collins and I prepare for a case, we like to look for what we call a theme. And what I mean by theme, ladies and gentlemen, is when you have a case and examine a case, you have witnesses, some civilian, some professional. You've got some evidence, some physical, some circumstantial, and those all sit on the periphery of a case. But the theme, ladies and gentlemen, is what's at the core fundamental concept of a case. And so the theme of this case, the core fundamental concept, is one of justification. And that was because the mistake that Adam Coy made on December 22nd, 2020 was reasonable because he was acting in accordance with his training. Now that is because the evidence will show that on December 22nd, 2020, Adam Coy was justified when he made the decision to use deadly force. Because number one, he had a subjective belief that he was in immediate fear of great bodily harm or death. And number two, that belief was objectively reasonable based on the totality of the circumstances when viewed through the eyes of a reasonable police officer on the scene without the benefit of 2020 hindsight. And that's because, ladies and gentlemen, the evidence will show that Adam Coy saw the glint of steel being leveled at his direction, believed it to be a gun. He was mistaken, and the evidence will show that that mistake was reasonable. And we will prove that, ladies and gentlemen, by a preponderance of the evidence, or more likely than not. And as the judge will tell you, if you find that we have met our burden of proof of more likely than not, if we have proven justification to you, more likely than not, then that serves as a complete defense to all three charges. Now, with the benefit of hindsight, nobody in this courtroom disputes that December 22nd, 2020, the events that occurred were tragic. And it's not lost on us that someone lost a life. Someone lost a father and a friend. However, as the judge told you and will continue to remind you, that when you examine a case, when you analyze and when you decide a case, you must not consider sympathy or empathy. And it is a tough task, ladies and gentlemen, because undoubtedly the state of Ohio is going to try to use that we are all humans in this courtroom. I am warning you now that it's not easy, and it doesn't get any easier the more times you see a body-worn camera or the more times you see a gruesome photo. I am sure they will play the body-worn camera over and over and over again. They will slow it down for you, go frame by frame for you. They're going to show you graphic photos. They're hard to see. It's hard to hear. And it's hard because we ask you to be almost clinical in your analysis. But that's what the law requires. Again, whether you agree with it or disagree with it, that is what the judge has already told you, and I promise you, he will tell you again. And so every time the state plays that video, or you see that picture, you see that body-worn camera go frame by frame, Mr. Collins and I would ask that you keep in mind that admonition that the judge gave you, that as you took an oath as a juror, you are not to consider sympathy or empathy when deciding this case. Now, unlike the majority of the cases that we try in our criminal justice system, we have a burden here. However, that does not alleviate the state of Ohio from meeting its burden. It is they that must prove to you, beyond a reasonable doubt, each and every element of all three crimes charged. Beyond a reasonable doubt is our highest legal burden in our system. As the judge will tell you, it's proof of such nature you would rely upon it in your most important of your own affairs: care for an elderly parent, surgery for a child. And if they fail to prove all of those elements to you beyond a reasonable doubt, the judge will tell you your analysis stops there. Now, you're going to hear two competing theories that the state is pursuing against our client. One is saying that he shot to injure Mr. Hill, that he knowingly committed a felonious assault, which proximately resulted in the death. The evidence will show that he's not trained to shoot to injure. He's not trained to shoot to kill, but rather the evidence will show that he is trained to stop the threat of what he believed to be a revolver. The second theory is that he did not act knowingly, but rather he acted recklessly, with heedless indifference concerning the consequences of his actions. Again, ladies and gentlemen, the evidence will show that Adam Coy did what he was trained to do on December 22nd, 2020. Not shoot with heedless indifference, but trained to shoot to stop the threat. The evidence will show they are not going to meet their burden of proof, because the evidence will show, ladies and gentlemen, that the state started from a premise and worked backwards. The state will not be able to prove any of the mental elements beyond a reasonable doubt because of those conflicting theories. The state's own witnesses will support the defense of justification. And the expert that the state is going to call, a man by the name of Seth Stoughton, he comes to multiple conclusions. Listen to those conclusions, ladies and gentlemen. One is contradictory to what the judge is going to tell you. And a separate conclusion is the same exact conclusion that the defense experts come to. And that is that he will tell you if an officer believes a gun to be pointed at him, then that officer is justified in shooting. So that is why the state of Ohio will not be able to meet its burden. And again, if that is the case, the judge will tell you your analysis stops. But even if you find that somehow, despite what I've just told you, that the state of Ohio does in fact meet its burden, then and only then do you analyze the defense of justification. May I have the Elmo, Judge? And so this is the flow chart of how your analysis will go. First, you will analyze, did the state meet its burden of proof beyond a reasonable doubt? If no, your analysis stops there and your verdict is not guilty. If yes, then you must analyze the defense of justification. You must ask yourselves, did the defense prove justification by a preponderance of the evidence, or more likely than not? If yes, then your verdict will be not guilty. And if no, then your verdict will be guilty. Thank you, Your Honor. And so I want to talk about our burden, ladies and gentlemen. It's different than the state of Ohio's. Certainly not as high as the state of Ohio's. But we welcome that burden, ladies and gentlemen. We have to prove to you that our client was justified by a preponderance of the evidence. As the judge will tell you, a smidge over 50%, or more likely than not. So as you listen to the testimony and the defense that we put on, remember, we have to prove two prongs to you by preponderance of the evidence. Number one, the subjective component, that it is more likely than not that Adam Coy had a belief that he was in imminent fear of great bodily harm or death. And number two, the objective component, that it is more likely than not that his decision to use deadly force was reasonable, given the totality of the circumstances in the eyes of a reasonable police officer on the scene, going through everything my client did on December 22nd, 2020. Now, this is where the mistake comes into play, ladies and gentlemen. And that in that calculus of reasonable, we have to prove that the mistake Adam made was more likely than not reasonable, given the totality of the circumstances. Again, we have to prove that by a preponderance. So I'm asking that you keep those two components of justification in the back of your mind as you are listening to the testimony here. Is it more likely than not than when Adam saw what he believed to be a gun? Is it more likely than not that he was in fear for his life? And number two, is it more likely than not reasonable that he made a mistake when he saw the steel, the metal that resembled a gun in both size and color? Now, your task is not an easy one. And the judge is going to instruct you that you must analyze that second component from the eyes of a reasonable police officer on the scene. You must examine the totality of the circumstances, and the judge will tell you, can't use hindsight in your analysis. The judge will tell you, you must account for the fact that police officers are often forced to make split-second decisions in circumstances that are tense, uncertain, and rapidly evolving about the amount of force necessary in a particular situation. And there's a reason why the law of justification, ladies and gentlemen, is written in this fashion. And that's because unlike judges unlike juries, unlike me, officers on the beat are not afforded the luxury of armchair reflection. Every single day, our men and our women on our police force put on their uniform, not knowing if they're going to return to their home or their armchairs for doing their job. And the court will tell you that you have to take that into account, that they're required to do their job. And let me tell you a little bit about Adam Coy. 2 days after high school graduation, he joined the Army, was honorably discharged for fighting our country and earned a rank of Sergeant E5. He returned from the Army and immediately began his career in law enforcement. He's got 3 kids and a wife, and on December 22nd, 2020, he faced every law enforcement officer's nightmare. You are going to hear that on December 22nd, 2020, a little after 1:30 a.m., Adam was in the area of Ackerman and Olentangy when he was dispatched on a call for service to Oberlin Drive, 1054 Oberlin Drive. That was the first house that you guys went to on your jury view. He was dispatched on a 4848A suspicious car, suspicious person report because there was an SUV that had been turning off and on for some time. Adam arrived to 1054 Oberlin and approached that SUV that was in front of that address. The caller met Adam outside and told him, hold on, that's the wrong SUV. The SUV that was in front of my house had since moved, not to 1062, but to the third house that you guys went to, past 1062, down to 1070 Oberlin Drive. That SUV was in fact in front of 1054, but that suspicious vehicle had moved to 1070. So Adam pulls his cruiser behind the SUV and exited the cruiser as he was trained to do. He pulls offset, meaning he pulls up behind the car, but not directly behind, a little bit offset, as he was trained to do. As he approaches the driver's side of the SUV, the driver rolls down his window, makes an X with his arms with a cell phone in his right hand. He leans over as if he was hiding something. Before Adam can get a word out, he was shown this phone. And based on those actions, it was Adam's understanding that somebody was going to come outside, that he was waiting for someone. So based on these actions, the call, the fact that a suspicious person was sitting in a suspicious vehicle, that he appeared to be hiding something, that he was dismissive, that he seemed like he didn't want to speak to Adam Coy, that he appeared wide-eyed and jittery, Adam decided to watch, to make sure that what his understanding was, that this person was waiting for somebody, that was in fact the case. So he returns to his cruiser and he waits until in the area. He wants to see, is a person going to come out to the car, or is this person just going to leave? He's waiting for that. Now, what Miss Amlin didn't tell you, ladies and gentlemen, is that Adam gets back to his Columbus police cruiser. He opens the door. He sits in the cruiser with the door open, as he was trained to do. And after about 1 minute, the person in the vehicle opens the door of the SUV. He exits the SUV. As this is happening, Adam gets out of the driver's seat of his cruiser, stood next to his cruiser to observe what was going on. The person walks behind the SUV directly in front of Adam's cruiser, and he didn't go to the house that he was parked in front of. He didn't go up to 1070 Oberlin Drive. Instead, he went up to 1062 Oberlin Drive, and he pounded on the door. Nobody comes downstairs. Nobody turns on any lights. He waits and waits just less than a minute, and then proceeds to pound hard on the front door again. Again, all while Adam is observing. There's still no movement in the house, and it has remained dark. The person who was pounding on the door walks back to his SUV, opens the driver's side door, leans in and is rummaging through some things as if he were looking for something. He then walks back toward 1062 again. And Adam asks, "Hey, what's going on?" And the person ignores him. Adam watches the person continue to ignore him, and as he's doing so, he keeps looking back to see what Adam is doing, seeing what Adam's response was. In the meantime, that is when Amy Detweiler pulls up. The state didn't want you to hear all of that in between, though. That is when Amy Detweiler pulls up, because she was dispatched too on the original suspicious person or suspicious call. The caller at 10:54 comes back outside, and Adam yells at him to go back inside for his own safety. Officer Detweiler exits her cruiser, and she and Officer Coy briefly communicate about something not being right, not knowing what is going on with the person they were sent to investigate. In the meantime, Adam and Amy lose track of where the person went. He disappeared. It is pitch black, ladies and gentlemen, at 1 a.m. You had the benefit of going to the scene in the daylight. However, in the eyes of Adam Coy and Officer Amy Detweiler, it was pitch black that night. So, Officer Detweiler and Officer Coy do what they're trained to do. They begin to look for the person to investigate what is going on. It was pitch black in the dead cold of winter. And at this point, nothing is adding up to Adam, and he lost sight of him. At this point, he has a duty to go forward at this point. And he will tell you, "I didn't know what was going on. I thought maybe it could have been a burglary or something to that effect. But at this point, I had to go investigate because I had what's called reasonable articulable suspicion to potentially believe a crime was being committed or was about to be committed." Adam Coy approaches the pine tree that you saw located between 1062 and 1070 Oberlin. The garage door was open. Something, again, that is not normal at 1:30 or 2 o'clock in the morning in the middle of the winter during the holiday season. There's no light in the garage. Adam sees a white car parked. He has his flashlight and he's scanning the area around the house. Initially, he doesn't see anybody in the garage. Then he sees a glow from a cell phone. He flashes his flashlight in that direction and sees the same suspicious individual that was in the car that ignored his commands huddled in the garage. Amy Detweiler has a different view. She pursues up the driveway and is to the right of Adam. As Adam is walking up the drive, he says, "Show yourself, come out here. Something's not adding up." The person turns his body with his shoulder partially bladed and begins walking toward Adam and Amy with his eyes fixed on Adam. The person has a cell phone in his left hand, raising about shoulder level. Adam will tell you that training dictates that he perceived that to mean he was being distracted, that was to serve as a distraction, because neither Adam nor Officer Detweiler could see the right hand. As he's approaching and as he clears the bumper of his vehicle, you will hear that Adam Coy believed a hand to be raising up, sees the metal glint of steel, yells, "Gun, gun," steps offline and fires 4 times until he sees that threat stop and he sees that threat drop. He immediately hits his body-worn camera. Columbus Police body-worn cameras at the time only had a 60-second look-back period. So you're going to see that body-worn camera did, in fact, capture the shooting. The video does not have audio at the time of the shooting, but you are going to see how quickly this all happened, how quick Adam was forced to make that split-second decision. Now, he doesn't let Officer Detweiler go right up to the person because he believes that person still had a gun. Once safe to approach, Adam does so, and he doesn't see a gun. But
So we're back live. We're back live. I'm not sure what's going on, but we're back live. Let me put it on. The court is back. So here we go. Where is it? Here we go. I think no, not that one. Oh, sorry. That's what. Now I know what I've done. Need to find it now. Bear with me, people. Because I got it in another tab. Wrong one. I'll just pause it for a second. I don't know if it's a verdict or not. We'll see now. Unless I can go back. Hang on.
My intent would be to have them call in or know that person. Can we be provided with the time?
Oh, question. It's a question.
Go back on the record. This is on State of Florida versus Lawrence Dority. Jury is out. The jury has provided a question. The question indicates, can we be provided with the time the officer, and then in parentheses, Morris, arrived to the scene, and it is signed and dated by the foreperson. Only for the record, both the state defense and Mr. Dority are present. My notes indicate that there was some indication that that time was at 1:30. I've asked the court reporter to find that section of the testimony in the transcript for a readback. She has that prepared. My intent would be to have them call in or have them brought in, have that question and answer read to them, and send them back out.
No objection from the state.
No objection. All right, ladies and gentlemen, I did receive a question from you all that indicates that you want to be provided with the time the officer, I believe that was Corporal Morris, who testified first, arrived at the scene, and it is signed and dated by the foreperson. You have to rely upon the evidence that was provided during the trial. I did have the court reporter locate that information in the transcript, and so she's going to read to you as part of a readback the question and the answer as it relates to that question. Okay?
Question. And did you have occasion on that date around 1:30 a.m. to respond to 2529 Secret Forest Drive in Orlando? Answer, yes, I did.
All right, that's the only evidence that we have that was provided as it relates from Corporal Morris that's responsive to the question, okay? All right, so you're free to go back and continue your deliberations at this time. All right, go ahead, have a seat. All right, we will be in recess again until such time as we have a question or a verdict. Again, remain within 10 to 15 minutes walk or return to the courtroom. All right, thank you all.
Yeah, I don't really understand what the purpose of that question was. She just basically said 1:30 was his arrival at the time. I don't really understand. Listen, as far as I'm concerned, they're asking questions. Oh, hang on. No, the defense brought up a notion that the scene could have been tampered with before the cops arrived. Oh, see, Mexi's on it. Mexi's on it, people. On it like a car bonnet, Mexi is. I didn't even think about that. Well done, Mexi. Gold star for Mexi. I'm downgrading it because I can. But anyway, right, we'll go back to the other one now then. Let me restart this live on the other tab so I don't lose it. And then, right, we're live there. Okay, here we go. I just, whatever the questions are, I always think it's good as long as, well, I mean, to be fair, your Migo stars for coping with you, Hack. They're asking questions, so I like that. At least they're deliberating, asking questions. So I prefer that to no questions at all. So I think it's a positive thing. Right, let's get back to this one then. Hack always got a gold star, Hackster. Erin, hack, 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 ole! Right, is this what it is? Why can't it? Right, there you go. I got it. You're my fire, my desire, Erin, hack, hack, hack.
Instead, he sees a mass of silver keys on a key with a key fob. You will see this metal mass of keys, ladies and gentlemen. He realized he was mistaken about the mass of keys being a revolver. He was in total shock and he became physically ill. The evidence will show, ladies and gentlemen, that based on that account of events that I just told you, that we will have met our burden. Number one, that Adam had a subjective belief, that it was more likely than not that when Adam believed he saw a firearm in that hand, that he was more likely than not afraid for his life. And number two, that he was objectively reasonable, that his action to use deadly force was objectively reasonable based on the totality of the circumstances. His actions were reasonable because he acted in accordance with his training when viewed from the eyes of a reasonable police officer on the scene without the benefit of 20/20 hindsight. And even though that he was mistaken, the evidence will show that that mistake was reasonable because the keys were both similar in size and color to that of a revolver. Now, Amy Detweiler, the state's own witness, is going to provide you corroboration of the defensive justification. She's going to provide you corroboration that Adam yelled, "Gun, gun," before firing. She's going to provide you corroboration that he does not let her approach immediately after because he still believed that a weapon was within reach. Now, the second prong of justification I want to focus on for a moment. How are you going to know what a reasonable police officer, how that person would have acted? How are you going to know about these national police standards that the state and I keep talking about? You're going to hear from two defense experts, decorated law enforcement officers with more years of law enforcement experience than I have on this earth. Between the two of them, they have trained thousands of law enforcement officers all over the world on deadly force. Particularly, they've trained officers in this city and in this state. Their names are Kevin Davis and Jim Scanlon, both certified trained police officers here in the state of Ohio and now retired. Kevin Davis has been in law enforcement for almost 40 years, and he's a certified force analyst. Jim Scanlon was a law enforcement officer for 33 years, 19 of which he served on SWAT. He started his own company in 1999, where he consults and trains officers with officers involved in shootings, firearms, hostage barricade situations, and critical incident training. Listen to the two defense experts and compare them to the state of Ohio's expert. The evidence will show that the state's expert does not hold a candle to the defense experts when it comes to qualifications. Now, Jim Scanlon and Kevin Davis use different methodologies in analyzing this use of force, but they are going to come to the same conclusion. They are going to tell you why and how Adam acted accordance with national training and police procedures. They're going to help you analyze what a reasonable police officer would do. Listen, as one of our experts will tell you, why Hill's actions dictated what Adam did next. Then, after standing in Adam's Coy's shoes, experienced what he experienced, as our expert will tell you, Listen, as they will tell you, it required immediate action on behalf of my client. One of our experts are going to walk you through some factors. These factors will be mentioned in the jury instructions that the judge will give you. Keep these factors in the back of your mind as our expert talks to you about them. Number one, the severity of the crime at issue. Listen, as our expert will tell you, that Adam Coy had a lawful objective for taking action. He had a duty to go forward. He will tell you that there is no more severe crime, or I apologize, there is no more severe threat than thinking that a gun is being pointed at you as a police officer. The second factor, whether the person posed an immediate threat. Listen, as our expert will tell you, that officers are trained that the actual possession of a gun is irrelevant. That what matters is the perceived threat based on how the object in the hand was presented. There's no question, as the evidence will show, that based on training, when a perceived threat is a person with a gun, that they are an immediate threat. Evidence will show that Coy's decision to use deadly force when examining this factor is more likely than not reasonable. And the third factor that you will hear these experts discuss is whether the suspect was actively resisting or attempting to evade arrest. You're going to hear that the person was non-responsive, that he disappeared, that he ignored Coy. And so evidence will show that when you analyze this factor, it is more likely than not reasonable with his use of deadly force. You are going to hear, ladies and gentlemen, how officers are trained, what they are trained to believe as if it is second nature. You're going to hear about threat patterns that officers have to train to indicate, recognize, process, and respond to these threat patterns. You're going to hear that they are trained to know that an action is always faster than a reaction. You are going to hear from experienced, trained law enforcement officers that when a hand comes up, an officer does not need to be sure that there is a firearm in that hand before responding with deadly force. You are going to hear that Adam Coy waited until he saw that glint of steel come up in his hand. You are going to hear from experienced, trained law enforcement officers that an officer is allowed to be mistaken. And you are going to hear from experienced, trained law enforcement officers that a perceived threat is enough. You are going to hear and you are going to see why that mistake is more likely than not reasonable in the dark based on the totality of the circumstances. You're going to hear about the limitations of seeing in the dark. You're going to hear about the limitations of what the body-worn camera captures. You're going to hear time and time again that the camera does not capture everything that our eyes do. And you're going to hear and see everything that that camera captured versus what Adam Coy perceived on that night. Now, the state's expert, Seth Stoughton, I think he was a police officer for maybe 4 years and 7 months. He's got no experience here as a law enforcement officer in the state of Ohio, and certainly not in the area where the shooting took place. But even he, a much less experienced officer, will tell you that if an officer believes a gun is being leveled at him or her, they are allowed to shoot. Even he will tell you that you need not wait the glint of steel. Even he will tell you an action is faster than a reaction. And even he will tell you officers are allowed to make mistakes. In recap, ladies and gentlemen, the state of Ohio has the burden of proof here. They have to prove to you each and every element beyond a reasonable doubt. If they do that, only then do you get to our defense of justification. Our defense of justification is more likely than not. And as the evidence will show, at the end of the trial, the evidence will show that it is more likely than not that Adam Coy believed he was about to be shot because he believed that that person had a firearm in his hand. And the evidence will show that based on the totality of the circumstances, in the eyes of a reasonable police officer on the scene, experiencing what Adam Coy experienced on that day without the benefit of 2020 hindsight. The evidence will show, ladies and gentlemen, that that decision to use deadly force was more likely than not reasonable because he acted in accordance with his training, as he was trained to do. As such, at the end of trial, my partner, Mr. Collins, will come before you and ask that you find Adam Coy not guilty of all 3 charges. And that's because he was justified when he took those actions on December 22nd, 2020. I thank you for your time.
Thank you, Ms. Stevens. Counsel, please approach.
For fuck's sake. This is a trial from incident happening late, I think it's December 20th, 2020. So yeah, this is a police officer who shot a guy that he was going out to see in a residence. That was the opening statements. I will show you now his, he took the stand. So this is going to be him taking the stand. This is a couple of hours. So this is him taking the stand. I thought it'd be interesting to see this because not every day we get to see officers take the stand and stuff. So for their own defense. So then we'll play the verdict. Oh my.
All right, please raise your right hand. Do you swear or affirm?
So Aaron Hack, this is the defendant on the left. This is the judge on the right. The defendant's name is Adam Coy. And this is a state of Ohio trial. Aaron Hack, ole.
That the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, as you shall answer unto God under the pains and penalties of perjury. I do, Your Honor. You may be seated. You've heard me indicate to everyone how important it is to speak into the mic so that the ladies and gentlemen of the jury can hear you.
Yes, Your Honor.
All right, as well as how important it is to respond verbally. So for the record, please state your name, spelling your last.
Adam Carl Coy, C-O-Y.
Thank you. You may inquire.
Thank you very much, Your Honor. Good afternoon, Mr. Coy.
Good afternoon, sir.
May I call you Adam?
Yes, sir.
Thank you. How old are you, Adam?
I just turned 48, sir.
Are you married?
I am.
Your wife's name?
Jacqueline Nicole Coy.
How long have you been married?
We've been married for 23, together 25.
Took you 5 years to figure out to marry her? Is that what you're saying?
A couple years, sir.
All right. Do you have children?
Yes, sir.
How many?
I have 3 boys.
How old are they?
21, 19, and 17.
And where are they in their stages of life?
They're still trying to figure it out. They've got some jobs. One went to college and then decided it wasn't for him and came back home, but they're all doing well.
Okay. Where did you grow up, Adam?
I grew up in Union County.
Okay. Where did you go to high school?
North Union.
North Union High School?
Yes, sir.
Okay. And what year did you graduate?
I graduated in 1995.
What did you do after that?
2 days after high school, I was at Fort McClellan, Alabama for the Army for military police school.
Okay. Had you researched that before graduating?
Yes, sir.
Why did you want to enter the military?
My grandfather was a Marine MP, and I wanted to follow in his footsteps.
Can I ask you a favor, Adam?
Yes, sir.
Can you just slow down just a little bit?
Yes, sir.
Reporter. She has enough problems with me. Okay. What's it take to? I'm sorry. What branch did you enlist in?
It was the Army, sir.
And where were you stationed?
My first station was at Fort McClellan, Alabama. From there, I went to Fort Hood. From Fort Hood, I got deployed to Panama for the anniversary of the invasion. From there, I went back to Fort Hood. And again, was deployed to Johnston Atoll. It's 630 nautical miles west of Hawaii, out in the middle of the ocean. It's near Hawaii, 630 nautical miles. Johnston Atoll. I apologize. From there, I went back to Fort Hood, Texas, and I was discharged from Fort Hood.
Okay. So how long had you served in the military?
5 years, sir.
And what type of discharge?
Honorable, sir.
And what was your highest rank that you achieved?
Sergeant E5.
What does that mean for the ladies and gentlemen of the jury?
That your E5 is your rank. Your sergeant is what you wear on your collar, the 3 stripes.
After leaving the military, what did you do?
I returned back to Ohio. From there, I went to JCPenney and did loss prevention while I was attending the Delaware Police Academy.
What does that mean, the Delaware Police Academy, Adam?
It was I used my GI Bill to pay for the academy, and I went through the Ohio Peace Officer Training Academy that was based in Delaware.
And what was your purpose of doing that?
I was looking to get onto one of the forces around here.
Okay. Were you eventually hired by Delaware?
I was hired by Delaware County.
In what capacity?
I was a corrections officer.
And for how long?
A little over a year, sir.
Okay. After being a corrections officer there, what did you do next?
I was hired on to Columbus Police.
Okay. What year were you hired on at the Columbus Police Department?
In 2001, sir.
When you're hired on to the Columbus Police Department, do you also have to go through their OPATA or their training?
Yes, it was my 3rd academy, sir.
Okay, 3rd academy. Tell us about the 1st academy.
The 1st academy was military police at Fort McClellan.
2nd academy.
The Delaware County.
How long is that?
It takes approximately 6 months to go through the academy and do an evening classes.
Okay. And then the 3rd academy is Columbus?
Yes, it was a paid for or paid while you were attending academy.
Okay, and how long did that take?
It's approximately 6 months, sir.
Okay. And so when you graduate from the academy, are you a Columbus Division police officer?
You're still on probation at that point, sir.
What are your assignments or duties once you graduate from their academy?
You would go to patrol.
Okay. And are you just sent out on patrol on your own?
No, you're first going with a field training officer, an FTO, and they take you around and they explain all the things you learned from the academy. You're actually put into practical use.
Okay. So you have someone with more seniority and experience with you?
Yes, sir.
On a daily basis?
Yes, sir.
How long does that last for?
At that point in time, we had three field training officers, so it takes about 2.5, 3 months.
Okay. Now, when you went to these academies, you were trained on police practices and procedures?
Yes, sir.
Use of force?
Yes, sir.
Firearms?
Yes, sir.
Hand-to-hand combat?
Yes, sir.
All those types of things at all 3 academies?
Yes, sir. 3 times.
Okay. And eventually when you're, what's it called when you no longer need a training officer with you?
That you're in patrol at that point, sir.
Okay. And when did you go into patrol?
It would have been late 2001, early 2002. And I went to 16 precinct, which is the downtown area, C company, which is 3rd shift, 11P to 7A.
3rd shift is 11P to 7A.
Yes, sir.
Okay. And basic duties as a patrol officer, Adam?
You would respond to runs, dispatched runs. You would pick up traffic incidents on your own, things of that nature.
Okay. You'd have to follow up on calls?
Yes, sir.
What types of calls would you have in patrol?
And you can get anything from domestic violence to thefts to burglaries. It's to the broad range of we're the first contact in patrol.
OMVIs?
Yes, sir.
Noise complaints?
Yes, sir.
Everything that the other officers have testified here to, correct?
Yes, sir.
Okay. And subsequently, did you stay on that shift?
I moved to evening midwatch, which is a 10-hour shift, and it's 7P to 5A.
Okay. Evening midwatch. Let's start first with what does midwatch mean for ladies and gentlemen of the jury?
Midwatch means you're actually in a unit that covers the half shifts. You're there for half of 2nd shift and half of 3rd shift to cover shift changes.
So there's always people out there?
Yes, sir.
My understanding is midwatch patrol has a greater distance to patrol.
Yes, we cover the entire zone.
Okay. When a patrol officer is on a specific shift, 1st, 2nd, or 3rd, they don't cover an entire zone, correct?
No, they cover in precincts.
Okay, all right. How many precincts are on average in a zone?
It changes constantly, but I would say approximately 5 to 6.
Okay. All right. And why did you want to work? So I'm sorry, how long had you worked that shift?
The rest of my career, sir.
Why would you want to work from 7P till 5A?
It worked out good for our family. My wife worked during the day. I could be at home and have dinner ready for the kids when they got off the bus and we would all have dinner together, then they would go to bed and I would go to work.
While you were a Columbus City police officer for how long?
19 and a half years total, sir.
Okay. And while you were a Columbus police officer, did you have other assignments or other specialties?
Yes, I taught at the ordnance at the range, our firearms range.
You said you taught. What does that tell the ladies and gentlemen jury what you mean when you teach?
So I went and got additional certifications for pistol, revolver, shotgun, rifle, and executive protection through OPATA, the Ohio Peace Officer Training Academy. That allowed me to then go back to Columbus and teach firearms to the recruits and to day-to-day officers.
How much training did you have in order to be certified by OPATA as a weapons officer?
Each one of those courses is a 16 to 20 hour course, depending on if it's the pistol, the rifle, or the shotgun, but I went out each time.
Okay. So once you're certified there, you are now a firearm instructor. And where do you teach that aspect?
We taught at our range that Columbus has, and I also taught at the Union County range.
Okay. So when you mean teach at a range, is there classroom aspects to Columbus officers being trained in that?
Yes, we go in the classroom where we go over the details of the firearm itself, how to clean it, how to maintain it, what actions and things that you do with it. And then we also have range time where they actually go out and fire the weapons.
And they have to qualify?
They do.
What tell the ladies and gentlemen jury what qualifying means?
Qualify is the state has set a certain level that you must shoot at, a certain percentage. And it's different for each course that you're going through. You would set up your qualifications, they would come in and do those, but we would also do shoot and no shoot scenarios where we would set up targets that you could change out the hands to be different items.
Okay. And how long had you done that?
For approximately 9 years.
Okay. So in that 9 years, are you there at the range every day?
No, sir. I was on patrol. I was a guest instructor. I would go out and assist whenever they needed help.
Give the ladies and gentlemen jury an average over the 9 years, how often that would happen during the year?
2 or 3 times each year, they would call us out for requalification or recruit training.
How long would you spend out there, that 2 to 3 times a year?
It varied from time to time, but usually a few weeks at a time.
Okay. So you're out at the range on average about 6 weeks out of the year?
Yes, sir.
Okay. And in that situation, they have to qualify in the handling of a firearm, right?
Yes, sir.
Qualify in shooting a certain percentage at a target, correct?
Yes, sir.
And then they have to qualify in the shoot, don't shoot course.
Yes, sir.
What happens if they don't pass those?
If they don't pass the course, they could lose their badge and gun. But at that point in time when I was doing it, and they would have to come back out and retest again.
Okay. And you mentioned, are you testing brand new officers, regular officers, senior officers? Who are you training at that point in time?
All officers, sir.
Okay. Why?
Because when I would go out for the recruit training, that's what I was there for to get them through the academy. And then I would also go out and teach the rifle training. Those are usually seasoned officers, a lot of times with military background, that we would have issued a rifle for the street.
How were you trained to shoot at a perceived deadly threat?
Center mass, sir.
Okay. When do you stop shooting?
When the threat is stopped.
Okay. Are you trained to shoot at an extremity or injure them?
Absolutely not, sir.
Are you trained to kill them?
No, sir.
And is there any number of shots or number of things? Well, I'm sorry, strike. I apologize. On the course, when is the threat over?
Usually once the instructors either called it or the targets actually turn and face and turn away. We also had a robot that was on the ground that you could put the target on and move it around the barricades and things like that for them to get a more realistic feel for the training.
Right. And just, did you ever train with a dog concept?
Yes, we had some of our targets that we had was an attacking Rottweiler. So to teach officers that a dog could be a threat as well.
Have you ever trained where something was a threat at first, then wasn't, then became a threat again?
Yes, sir.
Okay. Why do you train on those types of things, Adam?
We're trying to give the students or the officers the best chance of a reality situation that they may come into and contact in the real world.
Based on your training as well as that you received in your experience, what does reasonable suspicion mean to you as a police officer, Adam?
Reasonable suspicion is when you have, Thoughts and ideas that a situation could be leading towards a crime and that you need to investigate further.
Okay. Is that the lowest level needed in law enforcement to go forward?
Yes, sir.
Okay. So how would you use reasonable suspicion on a daily basis as a patrol officer?
Absolutely.
Have you had times when you thought something was going to be happening and it turned out to be nothing?
Yes, sir.
Have you had times when you thought something was going to happen and it turned out that more investigation was needed?
Yes, sir.
Have you had times when you thought something was going to happen and you actually stopped a crime?
Absolutely.
Okay. So because you're thinking about reasonable suspicion, that doesn't mean that you're saying, yeah, that's 100% what's going on.
Correct.
It means that's why you're going forward to investigate.
Yes, sir.
Okay. And you've heard Mr. Pearson ask questions about Mr. Davis and other people about probable cause. That's to see somebody or arrest somebody.
Yes, sir.
Okay. In order to charge somebody, that's a higher level needed, correct?
Yes, sir, it is.
To investigate is simply going forward with reasonable suspicion.
Yes, sir.
I'm gonna object, leading.
Yeah.
I will.
No, rephrase. I mean, sustained.
They have it, right? That's fine. That's fine. Have you been mistaken about reasonable suspicion?
I have, sir.
Okay. All right. Adam, you've been in here, you've seen some pictures of yourself, correct?
I have.
All right. And between December 22nd, December of 2020 and today, you have some issues in your life with regards to treatment and medication that affect you, correct?
Yes, sir.
Shakes, other things, physical and mental side effects, correct?
I have lots of neuropathy, sir.
Okay. I apologize. I don't know what neuropathy is, but I won't go into it, okay? All right. I want to take you back to December 22nd of 2020, okay?
Yes, sir.
Were you on mid-watch that evening?
Yes, sir, I was.
Okay. That time of year, based on your experience and training, what are some crimes that are more likely what goes on that time of year with regards to patrol officers?
Usually at around Christmas time, there's a lot more items sitting in a house that are readily available to grab and take away. Burglaries and thefts really skyrocket during those times.
Aspects of garages?
Garage thefts, breaking into cars, stealing packages off of porches, all those things go up during the holidays.
Okay. Tell the jury if you remember how you started your shift that day. What normally would you do?
I would have drove to 5 Sub, which is at the corner of Cleveland and 11th, and that's where I would have gathered my equipment for the night and got my patrol vehicle.
Okay. And when you get there, what happens next?
We have roll call, sir.
Okay. What typically happens at roll call?
Roll call is where you talk to the other shifts. They can tell you anything that's going on that day, something that I might need to be aware of, any complaints that we have in the neighborhoods that you need to attend to, and you would talk with your other officers on where we were going to space out over the zone.
Okay. How many people are on, and what zone is it?
I was on zone 4 at the time, sir.
How many people would be on mid-watch with you during that time? Excuse me, how many officers? I apologize.
10 to 12, sir.
Okay. All right. What happens next?
I was assigned to 9031. I gathered all my equipment for the night, loaded my vehicle up, and went out on regular patrol.
Okay. Anything of significance prior to to having this run?
No, sir.
Okay. Tell the ladies and gentlemen jury what happens or what you remember about being dispatched on this run.
I was at around Ackerman and Olentangy. I was eating my lunch. The call came in for service for 16 on Oberlin Avenue. I set my lunch down and put my car in drive and started that way.
Okay. What's a 16, Adam?
I'm sorry. A 16 is a disturbance.
Okay.
Which the call itself came in, sounded more like a suspicious vehicle, suspicious person. It was that a silver SUV was turning it on and off repeatedly for the last couple hours.
Okay. So when you get this straight, when you hear this, it's not just, hey, 16 at this address. It's the type of run is a 16, but they tell you information.
Yes, sir.
Okay. So when you put your car to go there, you had that. What information did you have at that time?
That there was a vehicle sitting out in front of the 1054 Oberlin, that it had been turning on and off for several hours, and the caller was concerned.
Okay. When you hear that, based on your experience and training, what goes through your mind at that time, Adam?
At first, I thought it'd be due to the time of the year. a lot of homeless are starting and stopping the cars to reheat the inside of the car up so that they can stay warm.
Okay. All right. So how long do you think it took you to get to 1054 Oberlin?
Approximately 5 minutes.
Were you timing it?
No, sir, I was not.
Okay. What describe for the ladies and gentlemen of the jury, when you pulled up, did you pull up right in front of 1054?
I pulled up in front of 1054 Oberlin. There was a silver SUV there. I exited my vehicle and began to shine my flashlight on it. As I shined my flashlight on it, the caller came out the front door and said, "Sir, officer, that's not the right vehicle. It moved down there," and pointed further down the roadway.
Okay. So you took note of a silver SUV. You're out there investigating. You realize that the one that caller went is down farther.
Yes, sir.
Could you see that car?
I could, and I could see that it was running at the time because there was exhaust coming out of the back muffler.
Okay. Did you take note of that the fact that the car was in front of 1054, but now somewhere else? Did that come in? Did you take that into your thought process?
It seemed odd to me that the vehicle had sat there for a couple hours, and then right as the caller had called, that it had moved. But I took the caller for what he pointed out to me and told him I would investigate.
Okay. What did you do next?
I got back into my patrol vehicle and I pulled down behind the silver SUV, and I offset my bumper to their bumper the way we're taught to just make a traffic stop. It creates a lane that you can walk in that is safer for you to stand in.
Okay. And where did you pull down to?
I pulled down to 10. At that point, the vehicle was parked in front of 1070 Oberlin.
Okay. And from pictures, was it on the closest part of 1070 or the farthest part of 1070?
Right about the middle, sir.
Okay. All right. And what was your intent? What were you intending to do when you pulled up behind that vehicle on the offset? What was your intention?
To make contact with the person that was in the vehicle and ask them why they were there.
Okay. When you hear the term suspicious vehicle, suspicious person, do you then have reasonable suspicion to investigate further?
I need to, yes, sir.
Okay. You couldn't just go away?
No, sir.
Okay. So your intent is to approach. What happens next, Adam?
As I'm walking up to the vehicle, the driver puts down the driver's side window, takes his left arm, puts it on his right knee and his right hand, and he leans out and back towards me, showing me a cell phone.
Okay. So if you are the flag for the courtroom for the record, you're approaching like where the flag is, correct?
Yes, sir.
Okay. So the person is facing this way.
Yes, sir.
Okay. So would you show that again for the ladies and gentlemen jury? Okay. And where are you in relation to that flag, so to speak?
I was walking up towards the vehicle.
Apologize. How far away do you think you were from the window at that point?
Be about 6 feet, maybe.
Okay. And then what happens next, Adam?
The driver says that I'm waiting for someone to come out. They're going to be out in a second.
Okay. Did the driver show you something?
He showed me the screen. I could see that it was a text screen. You could see the text bubbles, but I couldn't read anything on it.
Okay. So at this point in time, what's going through your thought process?
That this person's just picking somebody up and they're about to leave.
No issues, right?
No issues, sir.
Okay. Are you leaving at that point?
No, I tell the driver that I had to respond because we received the call, and to have a good evening. Went back to my vehicle. I opened the door. I sat in the driver's seat and left my door open.
Why would you leave your door open?
It's the way we're trained. It's so you can get out of the vehicle quickly if you need to. And I do it every single time.
When you are up talking to the person in the vehicle that shows you, what did you notice about the car?
The dark tinted windows, and there was a lot of items in the car.
Okay. What did you notice about the individual that you were having that conversation with? How did that person seem to you?
He seemed wide-eyed, a little jittery, and dismissive of me. He wanted to break contact with me as soon as he could.
It's not uncommon for someone to encounter a police officer to be bright-eyed and jittery.
No, sir.
It's not uncommon for civilians to not want to talk to officers, right?
That is correct, sir.
Okay. Why did you note those things?
It's just part of our training. It's what we see. We're watching for all these physical cues that a person gives. A lot of times you can read the body language and then add that to what they're telling you, and it gives you the bigger picture.
Once he showed you the phone and told you something to the effect that someone will be right out, what did you tell him?
To have a good evening.
Okay. And so now you're back at the cruiser. What do you do at that point?
I sat down again. I left that door open, And I reach over, and we have a computer that's mounted to our dash. It's called an MDC. And I read the license plate off the back of the vehicle and ran the tag. The tag came back, that everything was fine. It wasn't stolen. The tags belonged on a vehicle of that nature. And I didn't do anything further with it.
Okay. Did the tag come back to the address there?
It didn't come back to anything on Oberlin.
Okay. All right. So again, by itself, is that very suspicious?
If it would have came back to Oberlin, it would have been a lot easier for me to dismiss it. But the fact that it did not belong in the area made me think a little more about who he was picking up.
So when you're sitting in that car, why not just leave?
The caller was still standing in the front yard watching down where we were. I wanted the individual to see that I actually handled the problem and the person was leaving. So I was waiting for the individual to come out of the house, get in the car with the other individual, and leave the area.
Okay. All right. So you run the tag, right? Or you run the license plate.
Yes, sir.
And that kicks off a time, that kicks off a whole series through the lead system, right?
Yes, everything is recorded.
Right. And then at that point in time, had the individual left the vehicle yet?
Not at that time.
Okay. How long, I'm sorry, what happens next?
A minute or so goes by and the individual gets out of the car, comes to the rear of his vehicle, passes between my vehicle and his vehicle.
What do you do when you see the individual get out of the car?
At that point in time, I step out of the car and stand next to my vehicle.
Why?
Again, I don't want to be caught sitting down. I don't know what the situation is, and it's just the way my training is. I do it every time.
There's nothing wrong with a person getting out of the vehicle and coming in front of you,
No,
correct? Right. Why would you then get into the position you did?
because I do it every single time.
What do you observe at that point in time, Adam?
I observed the individual that was in the car walk to the front door, and
Where does he walk?
he walks up the driveway, and maybe,
I apologize. Is he walking up the driveway to 1070?
I'm sorry, he actually walks back down a short ways to the driveway that's more even with the back of my vehicle. It's 1062 Oberlin, the third address, and walks up to that front door.
Okay. So from your position of where you are, the individual comes in front of you, right?
Yes, sir.
You're standing up and then comes down to your right.
Yes, sir.
And then the next house to your right is 1062,
Yes, sir.
goes up to that porch.
Yes, sir.
Was anything said by the individual to you at that point in time?
Not at that point in time, sir.
What happens next?
He bangs on the front door really hard, and waits for approximately a minute.
Okay, when he banged on the front door, did anyone come to the door?
No, sir.
Was there any reaction in the house?
Completely dark, sir.
No lights came on, anything of that nature?
That is correct.
Waits for a minute, what happens next?
He repeatedly knocks again.
Okay. What is going through your mind when he repeatedly knocks again? I'm sorry, I guess so. When he knocked repeatedly the second time, did anyone come to the door?
No, they did not.
Were there any lights that came on in the house or anything?
No, they did not.
What's going through your mind at that point, Adam?
It's something's not starting to add up because he said that this person was waiting on him and about to be out.
Okay, here we go. Another thing here. So let me get this teed up for us. Okay. The court is back in session, so
let's go ahead with part. We're back on the record. I'll note that both parties are present. Mr. Doherty's present. I've been advised that the jury has reached a verdict.
There you go, verdict.
So let's go ahead and bring the jurors back in.
Verdict time. Verdict is in, people. Yes, it is in. It is in. Let me make it live. Well, this is a guilty. So, but is it manslaughter, murder 2? What is it? We'll see. We shall.
All right, the verdict forms are in order. Madam Clerk, if you'll go ahead and please read the verdict.
In the Circuit Court of the Ninth Judicial Circuit in and for Orange County, Florida, the state of Florida versus Lawrence Dority, case number 2022 CF 5250. Verdict as to count 1. We, the jury, find the defendant guilty of second-degree murder as charged in the information. So say we all, dated at Orlando, Orange County, Florida, on this 30th day of July. Person. Special finding as to count 1. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, actually possess a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding as to count 1. If you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, discharge a firearm. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson. Special finding, if you found the defendant guilty of second-degree murder, you must then answer the following question. We, the jury, find that the defendant did, during the commission of the crime, due to the discharge of a firearm, cause the death to Adreian Payne. Special finding, if you found a defendant guilty of second-degree murder and manslaughter, lesser included crime, you must then answer the following question. We, the jury, find that during the commission of the crime, a firearm was personally carried, displayed, used, threatened to be used, or attempted to be used. So say we all, this 30th day of July, 2025, at Orlando, Orange County, Florida, sign the foreperson.
Either party wish to have the jury polled?
The state does not.
Defense does, Your Honor.
Madam Clerk, if you'll poll the jurors for me, please.
Juror number 902, is this your true and accurate verdict? Is this your true and accurate verdict? Juror number 558, is this your true and accurate verdict? Juror number 206, is this your true and accurate verdict? Juror number 4217, is this your true and accurate verdict? Juror number 484, is this your true and accurate verdict?
Yes.
Juror number 693, is this your true and accurate verdict? Thank you.
All right, ladies and gentlemen, I have one final instruction for you, and that is your instruction upon discharge. I do wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges that you enjoy as jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain in their own private affairs as long as they wish it. Therefore, the law gives each of you a unique privilege not to speak about your jury's work. Although you are at liberty to speak with anyone, you are also at liberty to refuse to speak to anyone. A request may come from those who are simply curious or from those who may seek to find fault with you, and it'll be up to each one of you individually to decide whether you wish to discuss your jury work with anyone or not, okay? I know that it's been a couple of days and it's been an inconvenience to you to come over here and give of your time, but it is very important to our system of justice and very important part of being an American citizen that we have jurors like you come in and decide these cases for us. For your time here the last 3 days, I do thank you for the efforts that you have put in and the work that you have done. If any of you all need an excuse for work, we will generate that for you that indicates that you have been here for the last 3 days. With that said, that will conclude your jury service in this case. With our sincere thanks, you should not get another summons for at least 1 year from today's date, okay? All right, thank you. All right, Spencer. All right, have a seat.
Say the floor word.
All right, is there any legal reason why we can't proceed to sentencing at this point?
Your Honor, I don't know if the defense is asking for a PSI or asking for something.
Is he entitled to a pre-sentence investigation?
He's not a convicted felon.
He has a prior dealing in stolen property that he's on probation for?
I'm not sure if he's adjudicated guilty.
I looked at it. He was a withhold adjudication.
I understand it was a plea of no contest and it was a withhold of adjudication. Have you all reviewed Florida statutes 921.231?
Not recently, Your Honor. Let's do that now.
921.31 subsection 1 with respect to pre-sentence investigation reports says that any circuit court of the state when the defendant in a criminal case has been found guilty or has entered a plea of nolo contendere or guilty, so a nolo plea previously would count as a conviction, may refer the case to a Department of Corrections for a pre-sentence investigation. So a nolo plea previously doesn't entitle him to a pre-sentence investigation. The state objection to their request?
I don't have an objection, Your Honor. It's in your discretion.
And the defense is requesting one?
Yes, Your Honor.
What I'll do is I'll go ahead and request the PSI so I can get some additional information. How much time do they normally take for those? 30 days? All right, I'll go ahead and order a PSI at this point. We'll set sentencing for August 29th, which is a Friday at 11 a.m. In the meantime, Mr. Dority will be remanded to the custody of the Orange County Sheriff's Office pending sentencing. Further from the state?
Nothing further from the state.
Defense?
No, Your Honor. Thank you,
All
Judge.
right, we'll be in recess.
All right, I just want to hear what, go back, 29th of August.
Mr. Dority will be remanded to the custody of the Orange County Sheriff's Office pending sentencing. Further. All right, I'll go ahead and order a PSI at this point. We'll set sentencing for August 29th, which is a Friday at 11 a.m. In the meantime, Mr. Dority will be remanded to the custody of the Orange County Sheriff's Office pending sentencing. Further from the state?
Nothing further from the state.
Defense?
No, Your Honor. Thank you,
All
Judge.
right, we'll be in recess.
Okay, I've got that written down. So, here she goes. Like, so EDB, Leslie's on with EDB today. So, I know a lot of people want to go and watch that. So, that's something I think some people want to go and watch. Ooh, nice. There you go, Tudley Pip. So Murder 2, that's the family. So yeah, for you, lovely. I know lack of investigation. There was some question about some of the investigation. I'll admit that. I just think it came down to the fact that he went back inside and came back outside and you know, self-defense. You have to prove that you were in danger, and I don't think the defense could prove that because he went inside to a safe space and then come back down, and people were around him saying, drop the gun, but he didn't drop the gun. So that's his girlfriend and family and friends, I believe. So yes, I agree. So sad. And to the family there. So as I said, you know, the Alessi is on with what do you call it? With EDB. So as well for you to watch that if you wanted to watch that. I think that'll be a cracking show. His son and dad, yeah, he left his son, but his father threatened to go inside. So I'm not sure if he did go inside and come back out or not. I don't know. But in my opinion, there was no need for him to go inside and come back out. There was no danger to anybody. So he should have not done that. That's very sad for her as well. I'm not going to continue with the other thing because I don't think many are interested in it. It's the Adam Coy. Adam Coy was found guilty, to no surprise to anybody. So he was sentenced to 15 years. So, so there you go. So yeah, I don't know. So tomorrow, we don't know yet. I don't know. 20 plus years. I don't know. Tomorrow, I might, if there's no new trial, I might play a old trial tomorrow. And by old, I mean they're out on verdict watch today. So it'll be probably a day trial. It's a current trial. It's the Billy Delgado trial from Texas, where he shoots his girlfriend. I think she survives. Oh, his ex-wife. Sorry, she survives. And it's day 3 today, and it's in closing statements and verdict watch. So so I might play that tomorrow if there's no new trial. So watch your space, basically, for that. We might do that because we can zoom through everything. So, right. So the verdict will probably come out today, people. So just to prepare yourselves. So, right, everybody. I will leave it at that. And thank you again. Oops, I put myself off. And I will see you 9 o'clock tomorrow. And I'll put that stream up. But if there's any changes, we'll watch a new stream. It's fine. So I'll be on at 9 o'clock Eastern tomorrow, wherever happens, and we'll take it from there. Thank you, everybody. Thank you for being here, and thank you for your support, as always. Love you all. Go back on the streets, Stacey, and I'll see you all later. Just remember, wrongfulpod.com as well. Take care, everyone. I got the outro. Same outro again, Zach. Take care.
How long till it feels like the wound's finally starting to heal? How long till it feels like I'm more than a spoke in a wheel? Most nights I feel that I'm not enough. I've had my share of Monday mornings when I can't get up. But when hope is lost and I come undone, I swear to God I'll survive. If it kills me too, I'm gonna get up and try. If it's the last thing I do, I've still got something to give. Though it hurts sometimes, I'm gonna get up and live until the day that I die. nights I feel that I'm not enough, but I refuse to spend my best years rotting in the sun. So when hope is lost and I come undone, I swear to God I'll survive. If it kills me too, I'm gonna get up and try. If it's the last thing I do, I've still got something to give. Though it hurts sometimes, I'm gonna get up and live until the day that I die. I swear to God I'll survive. I swear to God I'll survive. I swear to God I'll survive. If it kills me too, I'm gonna get up and try.